that, my lord, this matter, my lord, has allowed to be listed on 12th August, but due to the officer of this court could not trace out the file, they could not list the matter, my lord. My lord may be directed this file to be stressed out because the matter is already running as item number.
Stressed out automatically it will be listed, madam. What can be done?
My lord, they
See the situation of the courtroom. How this officer will trace out the file in?
my lord, they must keep a track in which number they maintain a diary.
Okay, give a complaint to the Chief Justice. My officers are not competent to trace out the file. What can be done?
My lord,
You have
kindly
given the list. I have mentioned the date. The officers are tracing out the file. If it is not tracing out the file, what the court will do? Nothing. Yes.
My lord, may I be permitted to mention the matter with regard to item number 154 of Tuesday's list? With regard to item number 154 of Tuesday's list, my lord, the matter has already been disposed of by your lordship's direction, and my name, my lord, has not been
SIR matter.
SIR matter.
SIR matter I will not correct because it is impossible for my court officers to SIR matter to trace out the file, correct the name and put the order in the file. That's why I am not allowing in any SIR matter for correction of the name. Sorry. Yes, on the list.
Blood, my lords. Blood, ma'am. Blood, may.
This matter.
Today is not the mentioning day, madam.
Blood, just may.
This one. Item number 52, my lord, but it was due to appear as your lordship ordered that in first 10 matters. This is the senior citizen matter. The SBI life insurance matter your lordship was hearing. May I be permitted to mention?
You persons are not understanding what is the meaning of writing in the cost title. The mentioning will be taken on Monday and Thursday. Every day you persons are coming and wasting the time of the court for half an hour for mentioning every day. Then you will take you are telling that my matter has not been taken up. Item number 20, item number 40. If you give the time to this court, the court will take the matters.
Blood, I'll not take 1 minute, blood. Just, very well. Blood, just one indulgence, if my lord permits.
The petitioners are directed to provide the original insurance policy, original premium receipts, whether the premiums have been paid in cash or by check or other required documents within a period of 2 weeks from the date, and if the petitioner submitted their documents to the LICI, shall pass the reason in speaking order within a period of 4 weeks from the date of receipt of the document after giving an opportunity according to the petition. Yes, next.
Lord, I am the respondent, state respondent.
For the union of.
Yes.
For the union of India.
ए फोन ये कौन वहां करके रखा
अपनी category টা दिया हम
yes
मतलब this is in regard to duty of the enumerator and supervisors.
yes
As I pointed out to your losses, we have been appointed as enumerator and one of them or two of the supervisors. We are questioning this notification, government notification that said we page 44.
yes
Dear losses will find this was issued by the director of joint director of school education.
yes who is for the respondent
I am the state respondent, my lord.
I am for the respondent, my lord. Respondent. India.
He's my leader, my lord, for Union of India.
Union of India.
what is the instruction
My lord, lordship kindly see the section 15A. Lordship kindly see at a glance.
This is the other day I placed it.
Lordship kindly see. And now I am coming at impugned order.
yes
Yes, my lord.
Now, my lord, interim order, my lord, as directed, it is annexed at P4 before your lordship.
Yes.
Annexed at P4. As directed, it is to inform him that census work should be done in such a way that academic activities in the school are not affected. Stop. And thereafter, the teachers may perform censor activities post-class hours, or, my lord, I emphasis on this line, or don't. My lord, there is no section 15A of this order. My lord, apart from this, another point is this, my lord, I find, my lord, 31 petitioners before your lordship. My lord, I don't know how much court fee they have paid. My lord, the cause of action of the individuals are different. My lord, in that regard, my lord, I am citing one judgment of the coordinate bench. Two judgments, my lord, there. One is the judgment passed by my lord Mr. Justice Vishwan Samudar when his lordship then was. Lordship, kindly see.
Yes. Yes.
My lord, item number 3 also similar matter, my lord. Same matter. My lord, my learned friend is appearing in item number 3. My lord,
For Union of India, I do not have.
no, state respondent. My lord, we got instructions. But unfortunately, spite of
Union.
Union of India to whom are sent? Item number 2. Oh.
Lord, I have been briefed in item number 4. Yesterday, I received the copy. I am yet to take instruction, but I believe my learned friend, Lord, has Mr. Dotto has got instruction in item 3. My Lord may have a look at this, Lord. Otherwise, it is.
My lord, actually, there is no such confliction. So far, the section 15A and the
Okay, if you are telling that during the weekends, then I am also taking the approval from the Chief Justice, because there are so many matters. Saturday, Sunday, the court will hold. Because of the SIR matters, so many matters. I will allow. You are taking it during the weekends, no? So I am also telling, okay, I will also take a decision with the approval of Chief Justice. Saturday, Sunday, the advocates will come.
You will also kindly see the instructions.
I am telling you, you are harping upon during weekends.
Yes.
During weekends, so teachers are not having any other work in the home in the Sunday, because weekend school is not closed on Saturday.
No, my lord, actually,
School is closed on Saturday or not? I am asking you. No.
School is there.
Then weekend is Sunday.
Sunday,
If a teacher is working 10 to 4 every day, coming from 40-60 kilometer away, and only one Sunday, you will tell that the Sunday they will work for the remuneration?
my lord, that's why I'm pointing out this, my lord. Actually, the cause of action is different.
That I will deal with. I will deal with. That with regard to whether the cause of action, 1 petitioner, 13 petition, that I am passing every day, I am dismissing every day 1 or 2 petitions. That much this court is having the knowledge.
He has got vast knowledge, I know.
No, I am not having the knowledge, but that much knowledge I am having, that the different cause of action, the parties, but the court has given some direction to you. What is your direction? What is your compliance? That then I will go to the technicalities.
My lord,
My lord, item number 2, 3, 4, 5, and 6, I suppose, are all identical.
Yes. No, because every day they are mentioning, so I have kept all together. So that the
Because 3 of them, Lord, I am also happening, so I thought it was.
so I have kept all this. Yes, what is the instruction of the state authority?
ABTM.
Brother.
Yeah, so charge. हाँ, हमारा
What I'm humbly submitting, Lordship, because Milord, yesterday all these matters were served on us, Milord. And Milord, the interim prayer which they are praying is in the nature of the final prayer also. Be that as it is, my Lord will give us some breather to come back to my
Well,
Lord.
16 onwards, your work is started. That is why I fixed this matter. 16 onwards, your work. That's why I fixed the matter, because this matter, the first matter has moved earlier. So I have given the time to the authorities for take instruction. That's why I'm asking the question to the learned advocate who is appearing for the state. But I find that
what concerned, Lordship, I don't know in those matters who is appearing, but item number.
You are appearing for whom?
But I am appearing for the union, Lordship. Here in this, I am in item number 4.
But I have no allegation against you, madam. I have, I don't have.
No, here only, Mr. Trivedi, the question which the petitioners have raised, they are not telling that they are not going, they will not work the census.
I appreciate.
As per this order, either they have to perform their work after the duty hours as a teacher or
on Saturday,
weekend. Correct. So it is the contentions of the petitioner. Okay, if the school is situated on the same village within the 3-4 kilometers, they are going every day home and coming. Here the case made out by the petitioners, they are coming from the 40-60 kilometers, 1 hour journey or 1.5 hour journey, 2 hour journey. They starts. If then 10 to 4 is the class school. If they leave the school 4, then if when the after school when they go for the census work, first thing, because 1 hour journey. One thing. Second thing, if Saturday, Sunday, the school is working is Saturday, only one Sunday. So that is the I ask, but they are bringing the same thing which the authority has given.
So the Saint Mary's judgment.
That's why I given the example. That I have given the example. See the button of the court. I am court is also writing for Saturday, Sunday. Let the all advocates come.
Submitting is, Milord, as far as Union of India is concerned, Milord. I can just act as an officer of Lordship to try to impress that Lordship. These sort of circumstances had arisen in other cases where the Honorable Supreme Court had said that this is possible, and Lordship, we will rely on Right to Children's Education, Right to Children's Education Act, Section 27.
That's why I'm not telling. See, all the teachers have not been engaged.
Lordships.
And if the administration is so keen to take the service of the teachers, first you to identify the teachers who are working nearby the school. Nearby the school, you have not identified. Simply given the out of the 20 teachers, 4 teachers have been given, whether they are residing nearby the school or they are coming outside of the school.
Even I raise your losses. Take example in a village area. I am a lady teacher. But I will go in the evening in the village area. Who will take my?
If it is within the college school area, 4 p.m. they can go up till the 7 and they can do the work. But here that is not the case. If you say no, they have made a wrong allegation, they are residing within the premises of within the area of the school, then.
My Lord, what I am very humbly submitting, because my Lord, what has fallen, my Lord, I am not joining issues at all. What is falling, my Lords? I am, as my Lord's officer, I will try to impress my Lords only on that fact that whether a truce can be there where the census work may also be done and teachers not be My lord,
not be hampered. Neither
but-
school.
well, they have a personal life, they have their own homely work, so you cannot be arbitrary at issues what is falling. My lord, only one, two or things, my lord, even being technical, lordship will kindly give me the amnesty. My lord, the petition which I am appearing, that is item number 3, which I have, if I am not mistaken, that is All Bengal Teachers Association and others. My lord, as
Item number 3. Association I will not entertain.
my
Association I will not entertain.
my lord,
I will not
Two
entertain the association.
my lord, then I
It is taking into consideration with regard to the personal liberty.
my lord, these are the only, as
This
far
is
as Union of India
It
is
is my
concerned.
own mind. If
I'm
the
great.
association is coming, then this court will not.
Tale Dada के ऊपर बोलते
This court will not take the associations.
Then my lord, let my learned
Then
senior
the
friend-
own education department's teacher is to be given go by. That I will not allow. If the person coming in person is difficulty, maybe 100 petition file, I will sit.
my lord, I'm grateful.
But I will not allow the
Then my lord, let my
association.
matter be
The
called.
political will not, cannot enter into the,
I'm grateful, my lord.
political entities will not enter into all these matters, sir. So, individual, I will see to this. Individual, I am with the, if I find that there is arbitrary.
Okay, these things. Union of-
Yes. I have gone through, there is nothing in the, only Supreme Court judgment that I am not denying. The court is also telling, yes, the census work is necessary, education is necessary. But see the, at the time of assigning the work, see the whether the petitioners, the person to whom you are assigning the work, able to do the work.
Yes, my lord, then lordship kindly direct the government to assess the issue, because since the petition is totally silent, which petition are residing at home,
Correct.
which place, and he is performing in which.
My lord, may I make submissions? Probably government will not be able to do like this. It's a huge task.
They will not do.
I'm also, my lord, I like to do my duty. My lord, this should be like your losses follow the guidelines of all other states. That's why I placed before losses. My lord, suppose in a school, there are 20 teachers.
Correct.
2 have been selected. They should be, my lord, take out of duty of the school. That should be the proper, that's the section 15A.
That's,
Your losses, I have, since I have given them the copy, I have, by way of supplementary affidavit, all those government circulars of the other state I have placed. Kindly take into consideration one after another, your lordships. So, this is, that's what I'm saying, your lordships.
yes, you have given on the last occasion.
That's each of the state,
Yes,
your lordships will find
I-
they should be treated as on duty and do that. I have to complete my work, your lordships, within a month. It's not humanly possible. And section 15A says that. It's very easy to say, do after school hours. Now, suppose I am not asked by your lordships. to
Have
do
you
court
considered
appearance
the
after 7
other
o'clock
states
in the evening.
memorandums?
My lord, in fact, I did not get any instructions in spite of the.
That is the problem of the state.
Lordship,
You have taken 3 days for taking instruction. On that day, he has argued the matter on this memorandums.
I sent the information through mail, lordship kindly see.
So then I am saying that
Then.
if you are not able to get the interim or instruction within 3 days, so what you will do?
Because central government direction will prevail upon me.
Mr. Trivedi, who is the education secretary
My lord, as far as state is concerned, or central?
here? Because this order has been issued by the state government.
My lord, I will
Of
assist,
school education.
my lord, I will assist, my lord. I'm having a word with
With
the
the
learned.
principal secretary education.
My lord, let me have a word with
See,
the learned.
all the states have their own rules.
My lord,
In a school,
yes, my lord.
my minimum 20 teachers.
Yes, my lord.
20 teachers, if 2 teachers or 3 teachers has been chosen, that teachers has been, the other teachers can be given the duty to take the classes of in absence of one. That is only 1 month. It
Well,
is
this
not
is secondary school. So for primary school, there are 5, 6 teachers. If you choose one,
can be given
you
that
can choose 3, 4, 5, so that the school can
can be
entirely become idle.
if you are given the order in bulk wise.
No,
All
state,
teacher. To all
Completely.
teacher.
on application of mine.
कौन portion? But we may also rely, Millard, on Supreme Court's judgment, Millard, Honorable Supreme Court, Millard. I will assist your lordship with that, but my lord, as far as
Yes,
two is concerned, Millard, I am not engaged, Millard, in that matter.
2008. 2008.
My learned friend can appear in all the matters, wherever Union of India is
Supreme
a
Court.
party.
That's why I'm telling this court is not against the order. See the predicament of the teachers
My
also,
lord,
how they,
my lord is trying to balance it. I totally, Millard,
be
bow down to
balanced.
whatever point, Millard.
it has to be balanced. So if you're giving where is the teacher, where is the order?
My lord, that order which has been challenged, lordship, that is at page 44 of my lord's
Yes,
brief.
44.
Onkon Sarkar is have, my lord, Onkon serial number 2, my lord, is
So
being
40
placed.
Yes, 44. 44. So how many, from that school, how many teachers have been given the work? All teachers?
Can't be, my lord.
How many teachers have been given the work?
That's they can say, your lordships.
Which school is
My lord,
working?
I have cited one example, your
As far as
lordship.
this petition is
I
concerned, I
supplement-
can find, my lord, there are up to number of petitioners.
I will deal with your lordships. That's I think
31 petitioners, my lord.
31.
They may be, in different schools, my lord.
My lord, so far kindly come to page 47. My lord, my residence is at Kakinada.
This is one. You're
I have given
31.
your lordships, kindly have a look at.
You have
Supplementary affidavit I have given.
you are 31 petitioners.
Yes, I have given the details, your lordships. My lord, address in my writ petition, my home address, your lordships will be getting. And the school where I am working, I am telling your lordships one by one.
But you are not given the details in the writ petition.
No, that's my lord, it's prepared because it has to be done immediately.
Every day I am telling, yes, the clients are coming, overnight you are preparing the writ petition. When the court has given the leave, then all coming with the supplementary affidavit.
So details, your lordships, kindly have a look at page 3 of this.
Without
supplementary
taking
affidavit.
without reading the papers, you filing the writ petition, and subsequently when the court started.
My lord,
proceeding, it was
amendments have
persons
been
are-
given, details I have given. Kindly, your lordships, page 3.
Yes.
First, Pallavi Devnath Das,
Hmm.
lady teacher. He comes from Kakinada to Taltola, Sialda area.
Page 3.
Page 3.
Yes.
My lord, he comes from Kakinada by train. Pallavi Devnath Das.
Which petition? Petition number?
My lord, petitioner number 29. Take up this, my lord, I am giving one.
Yes.
She is petitioner number 21, lady teacher. She comes from Kakinada. Your lordships will find from the my lord, cause title of his address, home address. Bhatpara, my lord, Narayanpur, Kakinada to North 24 Parganas. He comes to Taltola, his high school. 34 kilometers away from residence. Now his my lord, census duty as Boro Bazar, Kolkata. Now is Pikepara, North Calcutta. Boro number 4, Circle 7. Now, if he is to do his duty after the school hours, is it possible, my lord? Then you'll see next one. Chandrima Mondal Pore. My lord, kindly see his my lord, address, my lord, 27. He resides at my lord, Bawali, Nodakhali, South 24 Parganas. She has to come, your lordship, South 24 Parganas, 60 kilometers away from home and residence and school. Now he has to, in the same area, he has been given the my lord, election duty. Then when she will return census duty, all that census will, when she will come back, your lordships. If that's why, my lord, your lordships, consider all the government orders of all the states. Those teachers are treated as on duty. And that section, my lord, 15 capital A. It's not humanly possible. And so for jural relationship, my lord, I will argue. Court fees I can pay. Look, they're poor teachers. Each person has to come up before your lordships. It's a common order. Jural relationship, my lord, we are all teachers. And we are governed by the common order. Maybe, my lord, someone 60, someone 40. It doesn't make any difference. Some reasonable approach to be taken.
Yes.
And duty starts 16th August. This has to be completed by my lord, 1 month. And kindly have a look. I just remind your lordships my amendment in paragraph 6. Oh, no, my lord, paragraph, my lord, I just give your lordships the duty, the nature of duty. My lord, paragraph, page 13, paragraph 14. It's a huge task. It's not possible, my lord, like 1 day or 2 days. My lord, I have given your lordships one book, Census Manual of 2017 of the government. My lord,
Yes.
Milord, may I? Milord, as far as Milord, first of all, Milord, I know I'm taking technical points at the very outset, but Milord, if certain procedures have been, Milord, prescribed, it should be done in that manner only. First of all, Milord, I am saying, Milord, Milord kindly takes up page 44.
Yes.
It is on 3rd of August 2026.
Yes.
Today, Lordship, arguably we are on the 14th.
Yes.
14th, Lordship. Now, Lordship, if they would have come earlier, Milord,
Yes.
we would have been able to
File
comprehensively
7th August. File 7th August.
file 7th August. Milord. We could have been, but as far as the others are concerned, Milord, this was.
So that's why in one case,
Milord,
that's why Mr. Trivedi, I given what you are submitting. First day, learned advocate had appeared and I given chance when the matter was taken. This matter was
Milord,
taken on 11.
I take back my submission as far as this is because I am intermingling all it because I apologize. Milord.
And
Now, Milord,
and that's why this point will be taken. Then whenever the petition was moved, I kept all together. So the once instruction will
my lord,
suffice
my
to
lord,
all.
State is concerned, Milord, I am for the union, Milord. So my lord, my extent is very limited because, as rightly said by my learned senior friend, that but my lord, why?
the allegation against Union of India. Don't
My lord, the work is something to do with
Now the situation has changed.
No,
you
may
can
I
say
suggest
that you
one
can-
thing? May I suggest one thing? Because, I have to perform duty. Now I am under the Union of
Okay,
India.
let Mr. Trivedi complete.
Now, Lordship will kindly see the supplement. Initially, my lord goes through the four corners of the petition. Now it is being supplemented because what has rightly fallen from your Lordship, that if the individual teachers have come who are facing this difficulty, my lord, that needs to be considered by this honorable court, and state being a welfare state also is duty bound to do that. Now, Lordship, as far as my learned senior friend's supplementary affidavit is concerned, what I am humbly submitting is that we are coming by way of a supplementary affidavit and buttressing the contention is neither here nor there. If they are coming up with certain substantial, they should amend their petition. Be that as it may. Now, my lord, that is my first contention. Second is, if my lord kindly comes to page 3 of the supplementary affidavit, they are saying, my lord, that the petitioners are resident of a particular area or a vicinity which is at quite a distance from the school which they are working in. Now, my lord, will kindly pardon my ignorance, but my lord, my understanding is that the petitioners have taken job in these places and they are out of their own volition residing at a distant place. Now that cannot be a subject matter for consideration before this honorable court.
This is not the transfer. This court has to consider
my lord,
as per your notification.
my lord.
You have given the notification. Either they have to after the classes over or during the weekend. So that's a practical question the court has put to the learned for the state. Okay, no problem. But in this situation, if the petitioner is coming from 40 kilometer in the West Bengal, minimum 1.5 hours journey.
Maybe
Correct.
more than that.
1.5 hours minimum. I am telling
Yes.
minimum half an hour journey, and class timing is 10 to 4. 10 to 4. If 10 to 4 and coming out from the court 4:30. School 4:30. If the 4:30, what time they will go for the work? And weekend it is not the Saturday is holiday. Saturday is one Sunday. That is the justification. You give the justification, there's nothing. That is
My lord, I bow down. My lord, I am relying, my lord, has already fought. The judgment of my lord, 2008, volume 2, SCC 390.
because
2008.
I have specified the learned advocate appearing, but he has not come with. I have specified this point, but you have not bring all these things.
Instruction
11. Now we are on
in
15.
such a long time.
I am not going to, I am getting an item number 6.
Please. Yes.
So, my lord, here I have instructions as far as 6 is concerned. I believe, my lord, in this matter, I can see, my lord,
So I suppose the same instruction, my lord, if my lord kindly hears that instruction, maybe
Yes,
it
what
will
is
have come-
instruction? Give me. Because what he has instruction, yes, that instruction, nothing you go through. If this, if you this is instruction,
My lord, I apologize.
see. Repetition of the order and the Supreme Court judgment.
Mhm.
আরে সুপ্রিম কোর্ট জাজমেন্টটা কাটছিস কেন শুধু জাজমেন্ট করতে হবে যা জজকে বসিয়ে দিচ্ছি কত
these orders are there.
হ্যাঁ
But now, my lord, we are
এগুলো রিজনেবল অ্যাপ্রোচ
I will also place the Census Act of 1940.
I am not on that. I am only on that.
আই মিসডাইরেক্ট
What is your distance from court and your house? What is the distance?
7 kilometers.
6-7 kilometer. The teachers, they have given the specific, they are residing 48-60 kilometer. Tell me, I am not giving, tell me 40 kilometers journey. What is the time consuming the journey by bus or road, whatever it may be, or train, whatever it may be? 1.5 hours? Correct. And automatically the Saturday is the working day. School is Saturday is working day.
কেউ করে না।
Your authorities have informed before this court. I don't know.
কে বসে
Respondents have informed this.
বাজারটাও যেতে হয়
Saturday working day. So if the school timing is 10 to 4,
আর তুই তো নিরামিষ
school timing is 10 to 4,
আলু সিদ্ধ খাওয়াবে না
10 to 4. If the school timing is 10 to 4 and they have to go 1.5 hour journey. So when the after working hours, which time they will go for the census duty?
Needs to be decided on an individual basis.
That's what I'm telling.
দিস ইজ নট অন ইন্ডিভিজুয়াল বেসিস
Always 10 to 4, we do not know.
আমার
That's why I ask you, because today you are appearing, the learned advocate had appeared.
that's why I placed all the memorandum
11th, the man, this must raise, it was
Teacher doesn't
informed
ask
to the learned advocate, he has taken note of it, that, but no.
Unfortunate, my lord, my apologies. My lord, so it has to be treated on a case to case.
That's what I told. I will not take with regard to the union case. I will not take the case who has filed the union. I will outright dismiss the union who has filed through the union. I will dismiss that. With regard to the petition who are joint petitioners, I will take their affidavit singularly and I will pass out.
There, my lord, that is there. Because, my lord,
So what, but you have to come with.
may I put a question to my learned
And you have-
teachers council?
and that is not the other states have, it is not the problem. They have given the school and given the duty, but they will
Teacher
take
is
it
on
as
duty.
on duty
Those days
those days.
For
There-
those
there-
days, teacher was on
other
duty.
state also the RT is applicable.
there, my lord, realizes they want it to be on duty. They will, my lord, here there is a balance which is sought to be reached. They will, teaching will also happen, this work will also happen. My lord, this work is very important, my lord realizes that. My lord, this has from 2021, my lord, now because of COVID and other factors, it is happening now. My lord, now, my lord, in fact, all of us face this, my lord. In fact, our LR office staff had been requisition. It's a national, my lord, it's a national responsibility.
I am not, what I am telling, I am not telling you, but the physical, you have to see, the court, if the court will not pass any order,
My lord,
dismiss, how the work is to be executed, you tell me.
my lord, how many of them, my lord, will be, my lord, assuming, my lord, will be there at 4 PM, my lord. My lord, this is.
Why is teachers are not in the 4 PM?
My lord,
As for yes, I will record that. The state government telling that the teachers are not working till 4 PM.
them
I will record your statement. I will record your statement that the teachers are not working till 4 PM.
by submission, individually it has to be treated.
no not individually I exception to it may I put a question to myself
No, Mr. Sanyal. unless and until you prove this, all the, they are coming that.
My lord, I
then
take,
it's,
my lord, kindly visualize. My lord, I take your example. I take your losses. You know, this is not the fact exercise at all.
When will they reach?
This is severe objection from the state. They don't take the proper instructions.
This minute section 4 and 5 of Census Act.
Do that. Do that.
Face prosecution.
Do that.
Let them face prosecution.
Exactly. That's my point.
Court is interfering. That's why the court is in, and the court is have very good experience in the election. What the election commissioner has given the assurance before this court, the insurance will not take any action.
I am under the
The election insurance company issued a memo.
School authorities.
That's why that
My most humble submission, let this be treated on a case to case basis.
Yes, I will, that I will do.
6 kilometers from here.
That I will
Take to point B.
Because
From home, distance, how does it?
because your authority issued the order in a bulk basis without considering.
How about that?
To be done.
How about that?
Sir, I was there. I know how the state has to work. Not like this. Not like this. If you are the state, you had the total biodata of the person, where he reside, where he posted, what is the duty. At the time of transfer, what you are considering? You are not consider. At the time, what you are considering? You are not considering. Yes, he was posted here. This year he has completed. His house is there. Then he is entitled to that. Then why not taken the factor on that? If you are telling that on after the duty hours, then you have to consider after the duty of which at time they will perform the duty of the census.
Then we take every fact into account. Then we can submit every case for every submit.
Correct.
Now, your lordship, let me place it my own. In my case. Point নিচ্ছে. Let me place individually. Still like unreasonable approach হয়ে যাচ্ছে.
27 and 29, my lord. No specific amendment is there.
Which is not there, I will not allow. Which is there, I will
Now,
allow.
my lord, may I take your lordships?
Yes.
Kindly come to paragraph 15 of my petition. Then I will. What I have done by your supplementary with that I will also show.
Yes, no, I am asking, can I hear the matter or you take instruction further?
Because I do, my lord, last provision fell from my lord. I am not aware.
But
So I-
but your friend was there, 11. The same point was raised by this court. And the state, other states notification also been given. But your authority not consider. Your authority
Yes,
given
must
the
be clarity.
replica of that.
16 से कोटे तक implementation
Chalo, 16.
16 माने कौन Sunday
Persons have no, the government pleaders and the AG are not sitting with the government officers for settling the matter.
The one which I received, my lord, last night we received it, my lord, did it, my lord, but in this earlier matter, my lord, I am not aware.
What-
Just now, my lord.
what I was suggesting very humbly before my lord is, but my lord, whether it will not be proper for me to submit, but even taking that particular my lord will grant me fearlessness. You know, 16th is the implementation. Otherwise, what I was my lord humbly submitting is that my lord, what is falling from my lord, there can always be a middle way which I can find in one of the judgments
That I want really.
that is in 2010 SC Allahabad High Court's judgment, where these things. So, my lord, what I'm humbly submitting is in unnecessarily being at loggerheads and joining issues for the heck of it will serve, because we are a welfare state, be it union and be I can vouch for now for the state also. So, my lord, what I'm humbly submitting is, my lord, if my learned senior friends give me concession, then my lord will keep it on Monday. I will use my good office and I will ask the learned advocate general. I will go to him and we will try to come to a understanding as to how
Do that, your lordships. Do that.
To that effect, I will also suggest. I will tell the petitioners. I will tell the petitioners to give the what are the petitioner, give the details of the petitioners, where they reside, where they posted, what is the kilometer. And you consider along with your officers, come on Monday, first matter I will take.
I request my learned senior.
All the petitioners should give their details.
Only one
So
thing.
Well, Tuesday, if it is, then it will be easier
But
for.
the Monday not, then you assure that the authority.
Well, state.
Because it is a census.
Why?
That is also to be kept in mind in a census.
That's why I'm saying because. No, no. একদিন
আর এক মাসে ফিনিশ করতে হবে হ্যাঁ যেমন বিকাশ হয়েছে
No objection as far as doing this work is concerned.
That's why then.
Only
That's what I'm telling. That's what I'm telling.
on the
Only contention is that you are telling that you are the teacher and you after the duty hours. So if the duty is completed at 4 and they have to reach by 7 PM in their house, and it is not by the side of the school there is remuneration work, census work. It is another place. So what time they will complete the census work? And weekend only one Sunday.
otherwise I will be visited with penalty.
Weekend only Sunday. This is the only troubling in my mind.
Because otherwise they've done the training and everything.
Yeah. No, they are not challenging. They are only challenging. We are ready. But either they may be treated as a duty. They will go to their census work.
And not do the school work.
Not
Obviously, that's where we are.
no. Because you not problem. What you have done this issued the order in bulk basis. It should be a 5 teacher or 6 teacher in a school, so that the other teacher can be used for the teaching of the school if the teachers are not there, or alternative, one day she will go, one day she will go. There so many things can be adjusted. The half day.
Just your lordship, the same, I request Mr. Chatterjee, look at page 21. Page 21 of this. Done. You have the municipality says, kindly, we want this supplementary.
Supplementary.
Kolyani municipality. Minister Rivu will be there.
Say they put.
And has taken the view. Section 15A, 15B. Then, in view of the above statutory provisions, all headmasters, head of the institutions are hereby requested to treat the period during which the concerned teaching staff perform census duty as on duty.
That you can. No, even they will not if have been given the census duty. But the question is that you are taking the benefit of taking the recourse of the RT. Yes, teacher, but you have to teach the student, but you have also to make arrangement. You have also to make subsidiary arrangement, either half day or alternative, or the teachers who are not to all teachers, some selected teachers to be given to the census duty, some teachers is to be remain in the school. Yes, that's what I'm telling Mr. So Mr. Trivedi and Mr. Sanyal, and who is for the other petitioners?
Item number 6, I am for the petition.
Personal or
No, item number 6 personal.
Where the associations are there.
association? I will not allow.
My matter is personal.
As association, I will not allow.
Well, just.
All the petitioners except the association. All the petition what in the writ petition.
Not my individual. All joined in a single
Yes.
petition.
All the petitioner gives what you are given the details in the supplementary. In all petitioner, give the details. When he was posted, where he is residing,
All that-
when he posted, give the
That's the
details
only
to the evening to the SGI. Today evening you give, and he will sit together with the authorities tomorrow on 15 August. I don't think whether he will sit
Well,
tomorrow.
therefore, I'm beseeching.
He will discuss it at IT.
Tuesday,
Tuesday. Taking penal action.
Tuesday, I will take the matter as a personal. Tuesday, I will take the personal.
Two sources, just what is falling from my lord. Falls in this judgment, my lord will kindly see paragraph 5.
Allahabad judgment.
Allahabad High Court judgment, my lord. What is falling from my lord? That my lord will kindly see paragraph 6. 5 and 6, my lord will see. So my lord, that is what I am also wanting and what is falling from my lord. because मतलब
The court has to balance.
Three and four,
no, no, আমি দুটোই what individual matters are those?
three and four. Three and four হচ্ছে association.
The 3 and 4 is association.
They are not the Learned Council appearing for the respondent petitioners in item number 1. Item number 1 is where is 2? Is the 2? Huh? With the 2, A2, A3. All Bangan done. 3 will not take. Item number 2, item number 4.
3 and 4 is association.
4 I will not take. 5. 5 is different matter.
Malad 5 is fine.
That is also same matter.
No, Malad 5 is also, my lord, your lordship already decided that 25, 27 years back, they have to,
Not with regard to this matter.
Malad, the issue is same, but the last occasion, the other matter, your lordship has decided the issue. The problem is different.
That is different. That is different about the training. That is for the training.
That is for the training. Malad, they are now, Malad, similarly, they are now, Malad,
case established
that we have undergoing, Malad, 25, 27 session. Malad, training
Okay, you give the details to the ASGI.
Yes, Malad, we have, Malad, in the repetition, Malad.
Give the ASGI. 5. 2 and 5, na? 6 भी है.
6 is mine, Malad.
6 दे दो. The council for the council appearing in item number in WPA number 20480 of 2026, comma 2 का बाद 5 ना 20376 and 21277 of 2026 are directed to supply the details of the petitioner where they are residing, comma, which school they are posted, comma, what is the distance between the residence and the school. Yes, and the school, as well as the school timing and whether the school is working on Saturday or not. Let the details of each petitioners of each writ petitions shall be supplied to the learned ASGI by today. By today, full stop. Learned ASGI submit that. He will take instruction from the authorities. Let the matter appear on 18th August at the top under the same name.
May I indicate one thing, Malad, that will be helpful for the court. Because in pursuance of Saint Mary, that thereafter, Malad, my learned friend handed over 2010 Allahabad, Malad. In the year 2025, Malad, Allahabad High Court, by considering the Saint Mary and 2010, Malad, because of that in election duty, Malad, there is a criteria mentioned in the guideline that teacher is the last one. Because of that, Malad, well aware the fact that, Malad, because of the in pursuance of the RT Act, Malad, so it will be kind enough if they consider the other local authorities employee, Malad, for the.
Let they come. If they are not settling the issue, then I will decide the matter. Because this court wanted to keep the balance between the state and the petitioners. If the state is coming with some solution, then it's okay. If it is not, then we'll see to that.
We want to do the duty, but
That's what I'm telling. That is
consider it as a duty.
But item 3 and 4 are by.
with mat karo.
3 and 4.
Order accept karo.
Malad 3 and 4.
With karo.
But item 3 and 4.
Yes, next.
3 and 4.
3 and 4. 3. Yes, who is appearing for the 3?
I am afraid of making any submission. I have hard instruction. So far, 3 and 4 is concerned, lad, I have absolutely different prayer. Now, kindly take some my prayer D and F, D, E and F.
3 बोलो that
I don't
all Bengal
D, E and F. This is my prayer.
Help all Bengal Teachers Association.
E and F.
Appoint the enumerator, supervisor, constitute a
D is same. F.
treated a duty under the leading influence. So you wanted to treating them as a duty under
As duty. This is my prayer and F. Kindly see blood. Kindly see blood F. And may I kindly see section 15A once your lordship has read one time and again that one for my satisfaction that 15A. May I read that 15A once?
See, treated on duty, how because if it is the work, then you have to work. If you're telling that you are ready to go for the work after the duty hours or the weekend, so question of treating the duty, how it is, what purpose would be served?
1 second, your lordship has read my prayer. Kindly see section 15A once, vis-a-vis my prayer. May I read? No member of the census staff shall suffer any disability in service by reasons of being on census duty and the period by spent by him, this is important, on such census duty shall be deemed to be the duty under his leading employer. Exactly, this is my prayer.
So they are telling that you are not the staff.
Let it be recorded and I'll be leaving. This is first blood. Second blood, kindly see blood prayer F once. But this I understand that this is a sovereign duty of the state. I have to discharge it, blood. Prayer F, blood.
How the association has filed this?
Blood, the judgment cited by my learned friend.
The association. Where is your resolution?
For resolution, I'll be coming on Monday.
Sorry.
But I have resolution, I have taken resolution, I have annexed.
Why? Wow.
But it was so deserved. I have in the affidavit.
Coming with the as an association.
In the affidavit, I have stated.
What is stated? Who has affirmed the affidavit?
Not the secretary.
So how he has affirmed that?
Can you see that?
Can you come to it? The jurate portion does not say that. As far as my understanding, jurate portion, my lord will kindly see at page 20.
No.
29, jurate portion says, may I read? I am the petitioner number 5 in the instant
He is the teacher. He is the teacher of the.
He is filing in his personal capacity.
No, not personal. Well, there are teachers who are filing in personal capacity.
The jurate portion does not say his authorization.
Where I am the authorized.
Yes, that's what I'm saying.
Where the association has authorized him to file this
That is what a jurate portion does not even say that.
Where is that? You withdraw.
Well, my lord, the honorable court is never against them. You will come, my lord. Yesterday I was arguing. You will not do your duties and then. This is not with them.
Last paragraph, last line.
Last paragraph, last line of which?
First paragraph.
Yes. I have been duly authorized by the other petitioners.
Yes. But may I do one thing, let?
Where is the government? They are the petitioners are the members.
Yes. Paragraph 1, let. Paragraph 1. Paragraph 1, I can see. Fine, similar paragraph 1. If you your lordship is so I can produce that by your supplementary affidavit. But paragraph 1, I see. I have specifically stated that. And not the judgment cited by my learned friend, but that 2010 was filed by the organization of teachers.
Point was
I'll see that
issued in
2010 once.
अरे बाबा 2010 छेगा ওইটা কে করে
The petition is not maintainable, sir.
This judgment on similar issue.
The maintainability point was not, but here union is standing
Who has filed
strong and
but this is what
this is not because
and there are subsequent also where the public interest litigation was entertained
here
by the normal court
based in that
and let
Go.
but to satisfy your lordship's conscience,
All advocates will be accommodated.
to satisfy your lordship's conscience,
Union will also be accommodated in that.
may I do answer? To satisfy your lordship's conscience, may I bring the resolution of the union on the next email?
How you correct the affidavit portion? How you correct the affidavit portion? As per the affidavit, the
Petitioners are duly authorized, right? There must be a resolution authorizing this petitioner to affirm this affidavit. I have to produce that.
You do one thing, you take it, take back, come again, we'll see. Come on, man.
Take it to the body.
He will accept, he has not to serve the notice, Mr. Chakravarti will accept.
He can file on Monday and he can, my lord, always grants us leave, my lord, Tuesday along with.
My lordship fixes our matter on Tuesday.
Yes,
But then I will be coming back on Monday.
Other matters are there, okay, what you want is an order, then I will pass an order.
Join and file a fresh matter.
And counsel for the
By the same petition.
place for you to file, leave to withdraw the present date application with the liberty to file a press accordingly. WPA number 21034 of 2026 is dismissed as withdrawn, liberty to file a press.
Second, the next 2000.
Same.
Well, I understand.
He wants an assurance from the court for Monday.
Case make out for
Well, I will satisfy the question with that.
Monday I will take your matter at 4:30.
I am ready. I'm ready.
Yes, next.
এখন কোনটা?
Like 3 and 4 both.
3 and 4.
Five will come along.
I just, only, I will not take your lordship much time, I know, for 30 seconds, your lordship won't see, page, I have annexed your lordship order.
Correct, but you give the details and that also mention it.
It is not required details. Because, kindly see, just once your lordship, kindly, do not,
I understand. I have passed the order. I know
Yes,
you have been given not to attend the and the authorities directed you may treat it as a duty. So on two lines,
no.
can the two
No,
lines?
I am not on duty, my lord. We are released. All the teachers were released from the school for.
That's you give the note and give the details to the SGI. He will consider that.
একটু আমাদেরও খবরটা নিতে দাও তো ভালো, there can be a truce, no? Otherwise there will be a deadlock.
Because that fact might not be with the secretary.
Milord, that is not there with me, Milord. Milord, what is happening is, Milord, we are being given matters the fag end. Now, Milord, we are unable to assist, my lord, and some matters, Milord.
My petition, Union of India was not pursuing. I here and now, I can and my lord.
Come on that is necessary, Mama.
I'm right now. I'm serving.
Mr. Trivedi is available here. No.
Yeah, my lord, I am there.
Yes. Who is appearing for the 7?
But I appear for the petitioner. But it is completely on a legal issue. It's
My lord, please.
It's completely issue. And the statute,
How you can file in independent petition?
no, this is not on this. Completely
The state, how you can?
I can, Lord, I am the post, I can appear for the petitioner. Now, sometimes they will trust me with some matters. Now, Lord, this is the advantage of not taking a receipt.
This is the advantage, Milord. I must concede.
So, Lord, kindly have a look at the rules.
But I could not get that opportunity.
My lord was holding a post, Lord.
Yes.
What happened was, I am pursuing medical. What happened is my schedule cast certificate has been cancelled. Now I am on a completely legal issue. If my lord is with me, I have some case, otherwise not. Can you take the rules once? Just take rule 3. Lord, this is the West Bengal Scheduled Caste and Scheduled Tribe Identification Rule 1995. Kindly come to rule 3.
Yes.
So kindly allow me to proceed. I have my case on this only. That a person whose scheduled certificate issued does not belong to such caste or tribe, the certificate scheduled caste and scheduled tribe department as itself as to as to the truth and other instruction of truth and other startup situations, either we can show control. If it is satisfied, so in my case, this is I have he sitting. Kindly say what happens after this.
Who
Right.
initiated? SDO?
Um, so, please, so once he is satisfied, I will see ask you to supply submit the original document. Stage 2. Now stage 3. The certificate is inside being issue a notice to a show the certificate issued after taking that, he will issue a circular stating the grounds on which it is cancelled. Then 4, on explaining the period referred above, subject 3, the certificate issue notice shall fix the date of hearing of the case by which to a complaint. Certificate asking them to do so documentary evidence stored as the case subject of the trust or the tribe identity of the certificate. So he will ask me, give me so evidence, documentary evidence, against and favor, don't you decide. So first, satisfaction to the preliminary, second, quality, third, super, can you take 1.5? No, the certificate is already satisfied. The person in whose favor the certificate is issued does not cost or tribe as stating the certificate itself by order cancelled in some so after 3, another subsequent court, he will send me the copy of that order, notify the person concerned, to whom the certificate was issued by the authority, if any, before the certificate was produced. So, Lord, if I summarize this, the process is, I am the authority, I get information. I decide to initiate formal proceeding. I'll make a preliminary, satisfy my conscience, I'll initiate proceeding. I get a complaint, I make a preliminary inquiry, as well as I satisfy about the authenticity of the complaint. I issue notice to the concerned person, I informing him, I will initiate a proceeding document. Once that is done, I issue a show cause indicating grounds of cancellation, asking him to report the documents. Decide the matter, pass a reason and inform him. Can I come back to the petition now? Can you take me on page 36? Here, the letter written subdivision south, so and so subdivision south certificate. Informs me. And he tells about the 15th December. 37, 18 December. Sorry, 37. Deputy
So, cast certificate. So that like this is the inquiry. This is once again.
No, okay. Continue.
Either by still officer, don't connect at 39. There comes one case. So and so 20th of February. So
Yes.
so page 39 that page 52. Issue page 42.
No inquiry.
Nothing.
Yes.
So this is my case, nothing else. I'm starting with protect me for some time. If my lord is with me, let them blood. I can only pray with folded hands before your lordships.
And we grant me some time to take the documents from the department.
No, okay, you bring the total details,
Yes,
total
record.
report, whether the inquiry was conducted, what are the circumstances you have taken into consideration, and how it has been cancelled, whether the section 3 has been followed or not.
Rule 3 has been followed or not. Interim order.
When? No, but whether admission is,
But I'm studying in KPC. The interim order has to be stayed. My exam is from 17th. My exam is from 17th, the first semester exam.
where you mention,
First semester exam. কোথায় বলেছিস কোন paragraph এ?
where you mention,
Kindly give
where
me.
is the date sheet,
Kindly give me a minute, Murat.
where is the date sheet?
Just give me a second. কবে থেকে পরীক্ষাটা কোন প্যারাতে বলেছো?
পরীক্ষা তো নাই।
Paragraph 32. Paragraph 32, Murat, I'm told.
You might have been get the admission card, the schedule.
No, para 32. No, it is an internal examination. Para 32, admit card is not required. It is on the basis of the roll number. Para 32, 17th is the exam. Now, Murat, if my schedule.
Internal examination is commanding on.
No. Look. Achha.
You have a schedule.
But I have asked the father of the student not to get it. But Murat, if my lord stays the interim order, I can continue in the college.
No, interim order can, but you can allow to, if there is an exam you prove, then I will allow to let it be allowed to appear in the examination.
But for the present, if the cancellation is stayed, nobody will interfere in my course of study.
Let me see the report.
Yes.
See the report with, if your
Sir,
urgency, because you have mentioned the urgency.
No, that's give me a second.
You
What
have
is
made
getting?
the
No, that's
college
schedule
only as a party.
No.
How
But
the
college did not. College
but
because college has
how
got
the
nothing
interim
to do.
order can be passed?
But stays the operation of this order for a week, I can participate in the exam because it is passed without following law.
File the report, Mr. Chatterjee. I will consider, no problem. Let them file the report,
But
whether they follow the procedure.
If the college do not allow to study and continue.
That's why if you showed me that there is an exam, then I will naturally I will allow you.
No, in my regular study also, I'm studying in the college.
You do one thing, if you receive the schedule, they come informing the Tiwari, then I will take the.
If sit at 1 o'clock, I'll come back with this.
Come. If you
1 o'clock. এসেছে এরকম ভাবে কি জজ সাহেবকে দেওয়া যায় তোরা কি করিস
This is what is being given. I am also sharing it with your in-law. 12:30 তুই দেখে আয়।
which semester is appearing?
Fourth semester, I am told. But I am not very much aware of this, Milord. Second year final. There are total 8 or 9 semesters. Per year 2 semesters. 4 year 8 semesters medical course perhaps. তাই তো সুমিতাবু? Instruction. This it doesn't look nice that my lord is looking into the. It's very small, the letters.
The petitioner has filed the present writ
Lord,
application.
may I take my lord's leave?
Yes, yes. File the present writ application challenging the order of cancellation, rejection of the what certificate? Caste certificate. Caste certificate. Caste certificate. Yes.
One typographical error. My caste certificate number, your lordship will get at page 31.
Yes.
And in my prayer mallet, instead of 18 mallet, I have wrongly mentioned 19.
19 is there. And is
So
it?
mallet, kindly see WB 1803
हाँ.
and kindly see my prayer mallet.
अच्छा 190.
Yes, mallet, that's
हाँ क्या बोला? Challenging.
page 31 है.
Challenging the order of cancellation. Challenging the a certificate issued to the petitioner being certificate number WB 1803SC 2022-022-019 dated 18th April 2022 under which Pondra under the category Pondra POUNDI. ठीक है? Police. Land Council for the petition submit that the respondent authorities without following the procedure laid down in section 3 of the West Bengal Scheduled Castes and Scheduled Tribes within bracket identification bracket close rules 1995 have cancelled the caste certificate of the petitioner. He submitted that the petitioner is pursuing BDS course.
MBBS course,
Pursuing the MBBS course at
KPC Medical College.
At KPC Medical College.
Yes, mallet.
Medical College
And hospital.
College and hospital. Full stop. He submits that from 17th August 2026 till 25th of August 2026, there is an internal. Take phone is coming. There is an internal examination of the petitioner, but after the cancellation of the caste certificate of the petitioner, the college authority will not be allowed the petitioners to appear in the said internal examination. He prayed for interim order staying the order of rejection of the caste certificate dated 16th April, 18th. No. When it was cancelled?
Mallet, it was, we have seen in the Oscar portal on 12th of August. Mallet, kindly see page 43.
2026.
Page 43, Mallet.
12th August 2026. Full stop. Learned Council appearing for the state. State submit that. Just last evening he has received the brief, and as such he intend to take. He prays for time to take instruction. He prays for fixing the matter after a week. At the Learned Council with the parties, this court finds that the authorities have cancelled the caste certificate of the petitioner on 12th of August 2026, and on 17th August 2026 onwards there is an internal exam of the petitioner, and as such the college authorities are directed. College authority, that is which college?
Like KPC Medical College and
Medical College and Hospital is directed to allow the petitioner to to appear in the internal examination, which is commencing on 17th August 2026, but the result of the 2026, the result of the said exam be kept in abeyance till the next date of hearing. Full stop. खाली बोलो क्या बोला ना ऊपर बोला the college authority so and so examination which is going to be commencing on itna to 17th August 2020. Full stop. Now okay. The respondents are directed to file the report on or before when? Today we are on 14th. By 20th. By 21st. By 21st, after serving the copy to the land council for the petitioner, list the matter. The petitioner's liberty to take exception to the report, if any, by 24th. List the matter on 25th under the same heading within 5 matters. 26 ऊपर आएगा affidavit of service का
take a print out and hand it over to your lordship. Schedule custom. I appear for the petition. I am appealing for the Department of Science and Technology.
Yes. Which matter?
I don't know what it made. But then we'll takes it up on Tuesday. Kindly inform them for hearing.
That's
current non-functional.
You are appearing for?
I'm appearing for union.
Who is for the state?
State, we have not state, but union. State is here. State is here.
Register forms of society.
আপনি আছেন তো? State. বলুন যশোরকে মুখে বলুন।
You are appearing for whom?
Well, I will appear for state because I have an instruction from the learned GP that you will
For the state.
Why you are not ready?
I told you. Petition, now it is-
Why not? No, I said it is under.
They wanted something to tell. That the court is facing every day. Today I will record your name. Now after next day, then other will come. No, I am appearing. There is no brief. Then next day the brief is given. The third advocate will come. No.
We could not set up the house in order.
Yes, you are appearing for whom? You are appearing
For the state.
for the state number 1, 2, and 3. Number 1 and 2.
State 1 and 2.
1 and 2. And what about the 3? Union of India?
I'm appearing. Mr.
Union of India.
Chakraborty.
What about the 4 and 5?
That's 4 and 6.
Indian Science Congress. You are appearing?
Milord, I have something to say. Milord, this is an Article 12 association, Milord. Yes, late. Subject.
He is not the.
Does not have any.
Let it take instruction. Come on then.
Milord, Tuesday, Milord, retain its position, Milord. I have some urgency.
Learned counsel
Tuesday.
for the state respondent as well as the respondents number 32. 32? 32?
3 is union.
Respondent number 4. Praise for time to take instruction. According case is adjourned. Let the matter appear on 18th within 5 matters.
Good.
Next.
My lord, this is the matter, my lord, which had appeared on Wednesday, my lord. Here, my lord, my contract, the respondents had sought time, my lord, to take instructions. My contract, my lord, has been terminated and threat of invocation of bank guarantee and imposition of liquidated damages has been held out. I don't need to go into the merits of the matter, my lord, because admittedly, my lord, principles of natural justice have not been complied with. And my lord, the order is a with cause termination. It will have an effect on future contracts, on my reputation. So, my lord, my humble submission, my lord, is that, my lord, even without going into the merits of the matter, my lord, on the ground of violation of natural justice, this order should be set aside.
My lord, I was
And my lord, let a hearing be granted an opportunity to show cause, then my lord, they can pass whatever order they wish to pass, my lord. Kindly see
Who is appearing for the authorities?
I am for a state.
I am appearing for the respondent, my lord, state respondent.
My lord, I'm appearing for government e-market. Please respond number 3.
Who has issued the order?
Lordship, I have issued the order.
Yes.
If
your lordship kindly see, few document we need to see in the matter.
Then I will have to,
before
then
we-
I will place the case, my lord. In case he's not agreeable to this, then I'll place the case.
So what is your instruction? You have to argue the matter on merit.
Yes, my lord. I have to argue the matter.
Then I will argue, my lord. My lord, I had submitted a note, my lord, the last occasion.
The order records that on the last occasion they completed their submission.
No,
I
no,
was only there to
I
respond.
did not place the case at all, my lord. That note I've given, I handed over.
Yes.
Kindly see, my lord. My lord, I have challenged, my lord, an order dated 5th August 2026.
Yes.
Which, my lord, is the first annexure at page 30, my lord. So I kindly have the have page 30 of the writ petition.
Yes.
This is, my lord, will see. This is issued by the director ICDS, termination and cancellation of GEM contract number such and such for supply of 1,18,000 infant weighing scales. Whereas a contract bearing such and such, dated such and such for 1,18,000 infant weighing scales was awarded. Bulk supply. Then, my lord, will see the contract mandated strict conformity with specifications prescribed by Ministry of Women and Child Development, Government of India, and compliance with legal metrology requirements. Whereas testing by such and such revealed non-conformity. So, my lord, there's an allegation with approved specifications, calibration failures, sealing defects, and field level deficiency. Whereas, despite repeated communication, and kindly see, my lord, the last communication date is 25th August 2025, 1 year before this letter is issued. The firm failed to replace the rejected units or ensure compliance. Whereas district authorities reported persisted non-replacement and disruption of growth monitoring activities. Whereas the tender committee meeting, my lord, may again see the date, 12 December 2024, resolved that repeated failure in testing would invite appropriate action, including cancellation. Whereas the competent authority, upon due consideration, has concluded fundamental breach of contract has occurred, and then, my lord, will see it has decided to terminate and reserving the right to invoke performance security, recover liquidated damages, and in case of outstanding that is owed to me, it shall be restricted only to units that have passed CIPET ILM testing. Now, kindly see, my lord. So, my lord, kindly see the second page of the note, my lord. Here, my lord, admittedly, my lord, before entering into the merits, this order, my lord, has civil consequences. The first civil consequence, my lord, is termination of the contract itself, where I have a claim of over 6.50 crores in respect of goods supplied. Secondly, my lord, they have threatened to invoke the bank guarantee, impose liquidated damages, and restrict payment. This will also have an impact on my reputation. Now, my lord, admittedly, it is not their case that they have granted any hearing or opportunity to show cause, so it is in violation of natural justice. Now, my lord, prior to this, my lord, we had approached the MSME Facilitation Council in Meerut, where, my lord, before the MSME Facilitation Council, we have made a claim of 6.50 crores. They have not participated in the proceedings. They have not raised a counterclaim over there. Now, my lord, this, interestingly, my lord, kindly have annexure P26. This order, impugned order, my lord, has seen, has been passed on 5th August 26. And just 1 day before, my lord, annexure P26, which is page 280. Page 280, volume 2. Kindly have, my lord, volume 2. Page 280.
80?
Yes, my lord.
80 or 18?
Oh, 280, my lord.
Yes.
We have, my lord, by an email communicated an order passed by the Facilitation Council, which is on the page before that. The email is there, and before the email, my lord, will see is a minutes of meeting of the Facilitation Council in the arbitration. So, my lord, as soon as we communicate, they did not participate in the conciliation, that failed. And after that, my lord, when arbitration is invoked and the sitting is held, we communicate the first minutes of.
So if the arbitration is going on, so why you are not approach the arbitration?
Yes, my lord, exactly, my lord. There, my lord, my answer is, my lord, will see, my lord, page 4 of my note, my lord. Roman 2, I have addressed this issue. My lord, I cannot approach the arbitration, my lord, because for this reason that the arbitration under the MSME Act, my lord, is restricted to the disputes under section 17. In fact, my lord, the Supreme Court has also said that it is, I have referred to the Supreme Court decision, and my lord, in the section 11, my lord, this court has also held that, my lord, I have the compilation, I'll place it if my lord indicates. Now, my lord, quite clearly, my lord, the dispute, my lord, is restricted to section 17, and section 17 says recovery of money. So, my lord, MSME is not an option for me. I cannot approach the MSME for this. Now, secondly, my lord, secondly, my lord, they had in fact, my lord, earlier under the agreement, there is provision for arbitration and there is also provision for escalating a complaint with the GEM. They had escalated a complaint with the GEM which was closed. I mentioned that at page 3, my lord, para 6 of the note. And my lord, the corresponding page number, if my lord has volume 2, page 251. 250, sorry. Kindly have page 250, annexure P23, page 250. This is, my lord, the status of the complaint that they had filed. It says closed. And my lord, on the next page, my lord will see the reason for closing is given. It says the reason under which incident is raised falls under non-verifiable incident. Buyer has not submitted competent authority approval. Hence, the incident is closed. So they invoked the provision of making a complaint before the GEM, which was closed because they were not able to prove their case. Now, my lord, so far as this issue, my lord, my larger, my lord, my broader submission, my lord, today is that even assuming for a moment, my lord, today I am on the first date, my lord, even assuming for a moment that, my lord, I have a remedy under MSME, even assuming for a moment that I have a remedy under arbitration or under the civil suit, even then, my lord, where there is violation of natural justice, my lord, the remedy of writ is not excluded. Kindly have, my lord, there are several judgments I put in the compilation, but kindly, my lord, have the judgment at serial number 4, which is judgment at serial judgment at serial number 4, which my lord will see at page 70. Kindly see page 70 of this compilation. The judgment begins at page 70 and kindly have paragraph 7, which my lord will find at.
My lord, there is no quarrel. Yes, writ can lie. I admit and concede to that. Writ can lie. Alternative remedy is not an absolute bar. I concede to that.
Yes, kindly see. I'll just place this judgment for my satisfaction, my lord. Page 70 it begins. Now kindly see page 73. That is, sorry, para 7. So far as the view taken by the High Court that the remedy by way of recourse to arbitration clause was available to the appellants and therefore the writ petition filed by the appellants was liable to be dismissed is concerned, suffice it to observe that the rule of exclusion of writ jurisdiction by availability of an alternative remedy is a rule of discretion and not one of compulsion. In an appropriate case, in spite of availability of alternative remedy, High Court may still exercise writ jurisdiction in at least 3 contingencies. 1, where the writ petition seeks enforcement of any of the fundamental rights. 2, where there is failure of principles of natural justice. So, my lord, where there is failure of principles of natural justice, then there, my lord, the writ court may interfere. And in fact, in the facts of this case also, my lord, which I am citing, the kindly see that after that Whirlpool is cited, the present case attracts applicability of first 2 contingencies. Moreover, as noted, the petitioner's dealership, which is their bread and butter, came to be terminated. So, my lord, here also a dealership was terminated without compliance with the principles of natural justice, and hence the court, my lord, interfered.
Yes.
Now, my lord, now in fact the judgment that I cited. So, my lord, there are other judgments also, my lord. In fact, I have mentioned in the compilation, my lord, a decision.
He's not
He's not disputing that. So, my lord, secondly, my lord, here, as I mentioned, as I submitted that, my lord, barely because there is an alternative remedy will not bar me from approaching this honorable court. And, my lord, my humble submission today is, my lord, that irrespective of the MSME arbitration, irrespective of any suit remedy or any other remedy that I may have, my contract has been terminated by a state authority, my lord, without grant of any, and they have threatened to invoke the bank guarantee and impose liquidated damages. So, my lord, on the very face of this document at page 30, my lord, at the very least.
What is the prayer? What is the prayer at this stage?
No, my lord, I am only submitting, my lord, in case I was thinking that they would be agreeable to have, to consider it afresh after hearing us. But if they are not agreeable, my lord, then at this stage, my lord, if they want to file their affidavits, my lord, no further steps should be taken, my lord. They should not take any coercive steps in pursuance of this letter.
Okay.
My lord, I will frame my argument in 3 points. First, what is the subject matter of the contract? Second,
he has taken issue that he was taken by surprise by this termination notice. Second point. And the third point I will take, that when there is a pending litigation, can he? So far as no pending litigation before going to arbitration, yes, I can see to that. So Lordship, I will place before your Lordship few factors of this agreement which I was having with them. Lordship, kindly come to page 38. I will quickly place the things before your Lordship.
But before that,
yes, ma'am.
Come to the page 30.
30, 30. Yes,
impugned order.
Impugned order.
Yes. Page 30.
Yes, ma'am.
Got it. Come to the last but second para, whereas the third para, whereas despite repeated communications, that is 2024. Then
I would come to that, Lordship. That
come. Then 2024, and the last is of 2025. Got it? 16 May 2025.
Yes.
And 28th of May 2025. Correct. Now the last paragraph. Whereas the tender committee meeting data 25 resolved the repeated failure of testing to invite the including cancellation. If you are issuing the notice on 25 and you have taken the decision 24.
Thus, I will try to explain. Now, Lordship, I was showing to your Lordship is the material required, page 38. Quickly, we will see top of that general specification of the weight measure.
Page 38.
Yes, Lordship, at the top. I will only demonstrate how, I don't have the word, how they want to take out the money from the government car. But I will try to show.
Yes.
So, Lordship, this is what they wanted to sell me. This is the thing. Lordship, they have an experience on the matter. Now, kindly come to page 41.
No, 38, what you want? What you want to show?
Material what he was supplying to me. Top. General specification of the weight scale.
Correct.
For the infant. We will keep in mind because the weight measure for the infant is very crucial. Then, Lordship, kindly come to the same warranty, page 44. He has given me a warranty.
Correct.
Warranty, and then, Lordship, I will take your Lordship. So they have a warranty to me.
Yes.
Then, Lordship, I will take your Lordship to page 77. Guarantee and warranty.
Guarantee also warranty.
Guarantee and warranty. And then bottom of same page is the return policy.
Yes.
And the return policy at the bottom.
Yes.
So he is supposed to return.
Yes.
He will take return.
Yes.
Now, Lordship, kindly see the arbitration clause, which he has not disputed, page 80.
Yes.
Which is not in dispute. Now, Lordship, kindly see termination clause. Page 82. Lordship has got?
Yes.
So this is the framework of the agreement, Lordship. Lordship, then he took a point that I raised a complaint to someone. Then, Lordship, that is at page 83. That is called ground for administrative action, page 83. The action which he said that I raised a concern to GME and that is page 83.
Yes.
Lordship has got. Then, Lordship, that was an administrative action. Because I have to inform him how this gentleman has behaved with me, because he is a platform like MSTC. So, now, Lordship, kindly come to the one invoice only. Any invoice which is at page 131, but Lordship, that are not very legible. So, Lordship, I would like to see this invoice detail from his statement of claim, which is at page 200 and 201. Kindly see his invoice.
This is the detail of the invoice because in MSME he submitted. So I will try to see that from type letter so that it will be easier to see the entire chart. Lordship, it starts from 200.
200.
Yes, Lordship.
Or it starts from 198.
Yes, Lordship, but the invoice which I want to show is from 200.
Okay.
Lordship will say invoice date is from July 23 and the last invoice date is 19 March 2024. Lordship has seen?
No, 200 starts from.
And 202 is ends.
No, 200 it starts from 199. It
Yes.
starts from 12th of July 2023. 199 it starts from 12th of July 19 invoice dated and acceptance on 26th August. Got it?
Yes, Lordship. 12th July it starts.
Yes.
And it ends at page 202 end. This date is very crucial.
And what is the page number?
202, man. 19th March 2024.
19th, yes.
So 19th March 2024 was the last date of invoice, according to him before the MSC. So this is all the time he transacted with me. Now there is no transaction between us, only litigation after this date. Lordship has got?
Yes.
Now Lordship, kindly see, he has supplied me. These are all GST invoices. So his supply stops on that day. Now Lordship, after I receive, I cannot receive, use and later on say that this is your bad thing. So Lordship, now your Lordship kindly come to page 191. So I have shown Lordship, they had a liability to take the goods returned, warranty, guarantee, everything I have shown. Now kindly come to page 91. So immediately in 2024, March till he supplied me.
Page 191.
191.
Yes.
Then we had a minutes of meeting. Now Lordship, I must say, whenever he does a meeting with me, after he goes and gives me a letter that the recording was incorrect, latter part. But this, only one notice, 1 minute.
What is the date of the meeting?
18th, no, 5/7/2024.
5th July 2020.
And I communicated to him on 8th July 2024.
Yes.
Lordship, kindly see what is this meeting about. That we will find it next page, Lordship. The damage, Lordship has got. Next page.
Yes.
The following point were discussed in the meeting.
192.
Yes, my lord, it is not paginated here. Koto?
192.
192, yes, ma'am.
No.
192 is the letter.
Minutes of meeting, Lordship, recording.
Minutes of the meeting 191.
Yes.
Following points were discussed in the meeting.
One page number is?
Yes, 191 is the minutes of the meeting.
192 is the agenda.
No. ওরা বলছে জজ সাহেবের ওই পেজটাই 191. Yes, Lordship, this.
Yes.
What is discussed in the meeting?
Points were discussed, yes.
Lordship. The damage infometer infant weight scale already supplied to all districts have to be replaced within the next month. Lordship has got. By replacing, it means that the machine supplied before issuance of this, such and such stoppage of siege, which called CIPD such a replacement of physically damaged machine to be done for the machine supplied before issuance of letter of such and such. The supplier will bear the testing charges of such and such. So, Lordship, it is on that date. We categorically told them that this is your wrong thing you are doing with us. So, his invoices, moment we wanted to pay, we checked it, we found it is incorrect, we hold a meeting. Now, Lordship, kindly come to, because every time he goes out of the meeting and says that no, this was not wrong recording. Now, but this meeting, next, 25th July, which is this page?
193.
Which is this page?
26 July 2024, 193.
P14. Yes, my lord, 193. Lordship, kindly come to 193 or 194?
Yes.
Whichever. আমি জানি না ওদের একটা করে
194 is 25th July.
Lordship, I am referring to 25th July 2024 letter. Written by them. Now, Lordship, if we see, we hereby confirm that vehicle for lifting back of the wage will be reached to your place on such and such date, lifting back, and after the replacement shall complete as early as possible. Therefore, we request to please keep the material ready, hand over such. That means whatever we discussed in the meeting, on the latter date, he says, yes, I am going to do this.
Yes.
So, this part is clear. Contract says replacement. We informed him and he said we will do it. But Lordship, from the pleading, Lordship do not find anything. Then after this, we make good everything. That pleading, Lordship is not getting here. Now, Lordship, what he does? Now, Lordship, kindly come to.
So it was not replaced.
No, he did nothing. Then, Lordship, kindly come to 198.
Yes.
Lordship, this intimation for MSME. Lordship got it? So, Lordship, he has done this on 3rd of December 2024 at the bottom of that page.
What will be the page? This will be
Yes.
197, my lord.
Yes.
So, Lordship, then December he has gone there.
Yes.
Now, Lordship, kindly turn to the same letter, page which I have shown 200 and 200 up to 202, the invoices. Then, Lordship, kindly come to SOC. 200?
13 is the main page that you have.
No. Lordship, kindly say it starts from 208. Lordship, what?
Yes.
207 now.
207 or something, Lordship. So he filed the SOC. Now, Lordship, kindly come to he gave entire detail of the thing. Now, kindly come to para 20 of this, 214 or 213.
Yes. Para?
Lordship, para 20.
Yes.
He says that after filing of MSCB, the respondent had deliberately, maliciously cast false allegation against this. False allegation is what? That 12 letter, last letter. Because he filed in on 3rd.
Yes.
So, Lordship, I cannot have any knowledge of his filing at 3rd because that was an administrative filing on this. So, Lordship, he says that I made a false allegation, such and such, formally denied such letter by a reply dated 26/12. Now, Lordship, kindly see his prayer. Lordship, prayer of the SOC is at page 276.
This is the reference, it is not the SOC. SOC comes later.
No, 215.
277, Lordship, I am praying.
215 is the prayer.
No, that is the reference.
And then
18.
SOC starts at.
SOC is later.
So, SOC is
250.
prayer of
276 is the prayer in the SOC.
276. Kindly see.
Yes.
So, he has made a prayer. So, now formally arbitration is pending. And what are the prayer in arbitration? The award directing the respondent to pay outstanding sum of this, and award directing the respondent under section this, award directing the respondent such and such, award directing this. Now E. The declaratory prayer starts at E. Prayer E. To hold and declare that the respondent have accepted delivery of the substantial material of the infant weighing scale, retained possession thereof, sought replacement of certain unit, admitted reply such and such before micro such and such, after disputing its liability to make payment of such and such under this. And then F. So, Lordship, his declaratory prayer is also there. And the injunction will always to be in aid of that declaratory prayer. Next, F. Hold and declare that within the payment, despite acceptance of the retention of their supply, arbitrary contrary to such and such violation. Then the Lordship award court and this. So now Lordship kindly come to, this is his prayer. So declaratory prayer, last day when he argued, he tried to say, in a MSME, I can only obtain a money degree. So there he said a declaratory prayer because of that 5th July. Because 5th July we decided, 5th July he acted on that. And now Lordship kindly come to page 218. 218, 17, 16, P17.
Yes.
Lordship, this minutes I communicated to him on 20th December. And what was the meaning, Lordship?
Page 217.
Yes.
Yes.
The seller was informed that the payment should be initiated for the such and such and informed such and such and been received. Factor has been received from the district magistrate for which he has been generated subject to approval of the debtor. It was informed that earlier date of extension of GM portal such and such for uploading the challan of this such and such. Therefore, the such item delivered after due date of delivery, they are entered such and such as per GM. The supply infant such and such, if reject after the negative test report, if rejected after the negative test report, the bulk replacement of the rejected device falls within the test of such and such, will be taken against the seller subject to the approval of the company, some based such and such, such and such. So, Lordship, that this letter he denied. He said, no, this was never the condition and this with you. So now, in this juncture, Lordship, then Lordship, we will read the termination notice once. Page 30.
Yes.
So, Lordship, now when we were terminating, he says that I need a show cause. That's what his case is. Natural Justice Party is concerned. So, Lordship, from 5th July till December 5th July 24 till December 2025.
Yes.
Before that.
24, sir.
20.
So, during that period, I met him. I discussed with him. I have given him minutes. We supplied the minutes. He could have given a defense. 5th July, he agreed to me. From December, he started turning around. And then today, when arbitration is proceedings, in a de novo matter, he comes before your Lordship and say, my natural justice has been violated. So kindly stay. Now, what is the effect of this termination or stay? So, Lordship, what I am saying is, in a worse situation, if this court do not, he has an alternative. He is not remediless. Second, he is not in act with me that he has to supply. He is not saying that I have already procured and this is a special device. I cannot send it to you if you terminate. So only he wants to keep the contract open for some purposes which is known to him, maybe commercial prudence. But legally, he himself said, after March 2024, after the invoices, he said, I will make good the thing. And then till date, he has no business with me. So why should I keep the contract open? And the consequences of contract, he will injunct me from doing that in arbitration.
Okay.
That's all.
My lord, I have two short submissions.
The termination is okay, no problem, because he's not doing the business and arbitration proceeding is going on. But what about the recovery and the invocation of the performance guarantee?
There's a clear failure I have shown.
If it is the matter is pending with regard to the recovery and details, and you have termination because you are not having the contact with the petitioner
So-
is July 2020.
Now, Lordship,
24,
now,
December 2024. Now you have cancelled
Invocation.
the tender, no problem. But what about the invocation the purpose?
now, Lordship, invocation is, I have shown.
Hmm.
First, invocation, unless he pleads fraud upon me, that I have done a fraud and fraudulently I am taking it, he cannot stop me. Now, Lordship, in contrary to that, I am showing that he actually failed in his performance. 5th
No,
July.
that's correct. That's why that is the total merit. You have cancelled it. No problem.
It's cancellation and then failure in
Performance.
Lordship, my
But
guarantee.
the performance, why I am telling the performance, he is having the claim against you with regard to the material supplied
Oh.
before the MSN. Correct. So if tomorrow, if it is found he is entitled for that, and you again invoke the performance, what purpose should be served? So that's why that okay, cancellation, okay, no problem, cancellation to be decided at the on merit with regard to not to invoke the performance
Yes.
guarantee.
Now, Lordship, I am coming to that. For one part is over. Now, performance guarantee. Lordship, I have my guarantee. Today, I don't know whether I will go back with a counterclaim or not. Now, Lordship, today, what is the utility of this? Prima facie, he has to show fraudulently I am doing that he has not done. Now, second, I am going a step ahead and showing, Lordship, I have my guarantee and warranty, which he is not giving me. Second, he promised that he will replace. I have shown that he has also not done. So now, Lordship, if it is apparent on the record that my guarantee and warranty is no more with me, my replacement request made to him, which he agreed and admitted, it's from his document I am showing. And then also, Lordship, if Lordship stops me from invoking it, then Lordship, then where do I stand? How do I do business? This is a government. He has supplied me some wrong material. I have to purchase because this is a sensitive issue for the infant. I cannot keep my district hospitals or the maternity homes like that. So, Lordship, then
See, that's why I'm telling it. This court is not going into with regard to the staying of the operation of the
that's so now I'm saying
with regard to the performance. If the performance because it is with you only. It is not that the court is not passing any order to release the amount. He is not asking for that. The court is asking you, okay, you cancel. Okay, at this stage, will not let you file the affidavit. We will decide whether it is the cancellation is correct or not, legal or
if
illegal.
Lordship is saying that he will keep, no, Lordship, bank guarantee has got a tenure.
Yes.
If you Lordship stay today, tomorrow the tenure goes, then he is out.
That will continue with the.
This is one.
Continue.
And then Lordship says that Lordship will allow us to invoke subject to leave of this court or that court or
Why this court is worrying? Why this court is worrying? Because their claim before the arbitrator with regard to the material supply. Now you have cancelled that. That has to be decided by this court in the writ application.
But then, Lordship, if I
just a minute, it has to be decided. If it is decided, yes, the termination is wrong, and the arbitrator decided that yes, he is entitled for getting the bill amount from you. So where he will go? So if it is
let's equity. I understand what Lordship is saying. Lordship, first off, I'm government. I'm not a private party that I will go away with the money. Second, Lordship, performance he failed as per contract. Can't I? Because this is the glaring.
I am not telling you can't. I am telling you. Okay,
in future, if he wins,
you dissatisfied with the act of the petitioner with regard to the supply of materials which have been given with the work which has been given to the petitioner. There's no problem. Correct. I am also not satisfied that yes, the termination is wrong and it has to be stated. That nothing, and I don't think Mr. is praying for that. With regard to the performance, they have claimed their amount with regard to their it is pending before the MSN.
Yes.
With regard to the performance, if you invoke the performance also, it correct. If you invoke the performance and tomorrow an award is passed in favor of him, and if tomorrow the the cancellation of the tender is wrong, then what purpose should be served? Okay, let the performance remain with you and they will extend from time to time till the disposal of the.
Or lordship, let it be invoked and with
No,
the.
it has already, it has all the period, you have to inform the period has expired, but the claim period is dead till 2027.
So that means
So
that
now, my lord, my 27, it's there in the kindly, the bank guarantee is part of the record, page 94.
Where is that?
94, my lord, of the writ petition. Kindly see first, my lord, 94, the claim period, last paragraph. 16. Claim, if any, under this guarantee on or before 16 March 27, and my lord, the expiry period, my lord, will find.
Yes, that's right.
And my lord, may kindly see, my lord, page 97. Page 97, bottom of the page. Bank guarantee shall be valid up to 16 March 2026. So bank guarantee period has expired. They can claim up to 2027, my lords, this date 16 March 27. So, my lord, the 16 March 27 is still, my lord, there is time, my lord. Yes, my lord. So, my humble submission is, my lord, twofold. First is, my lord, the letter which they have shown is dated
Then in that
20th,
case, sorry.
20th December 2024. So, even as per them, my lord, the minutes is of 20th December 24, and we have responded to that. That letter is at page 280.
That is to be tested.
After 1 year, my lord, they suddenly.
That is to be tested.
Let them not take further steps in pursuance that and
further step. What that's what
liquidated damages, my lord.
bank
Yes, invocation,
nothing else.
liquidated damages also they have threatened, etc.
That's what I'm revocation of the bank guarantee. That is the only.
Then lordship, bank guarantee has already expired.
But
My claim period is this.
till March 27. Because the
Claim period. Bank guarantee has come to an end.
Correct.
So lordship, if they want that, then they have to replace it by a fresh bank guarantee.
It's to be extended.
Yes, bank guarantee to be extended.
The other alternative, my lord, if my learned friend is saying that he is consenting to the jurisdiction of the MSME, then let it be recorded. We'll go to MSME. In the meantime, let there be some.
I did
No,
not
in
say
submitting that, my lord, because the law is completely contrary, my lord.
No, because the prayer, the last prayer.
One declaratory prayer doesn't change the fact that I cannot challenge my contractual.
If the court has jurisdiction by my consent, it will not confirm.
So then, my lord, then that issue has to be tested.
But I said this.
The law is very clear, my lord.
If it is not there, then the arbitration is also with you. You left your general arbitration, you left your MSME.
Claims are being made in
disputed fact.
In defense before lordship, my lord. They have not even participated. Conciliation, they didn't participate.
Yes, they are bad.
They have they have participated. The proceedings going on before the.
They are bad boy.
Oh, so then, my lord, let bad boys suffer a bit, my lord, because the fact of the matter is, my lord, that in arbitration they are not participating. All these submissions which my learned friend is making over here.
The petitioner has filed.
My lord, just on behalf of government e-marketplace respondent number 3, my lord, I wanted to submit that there are absolutely no allegations made against GEM. My lord, can you hear me? My lord, can you hear me?
Yes.
Yes, my lord, I'm saying there are absolutely no allegations made against GEM. There are no relief sought against GEM. And to that extent, my lord is minded to keep this alive. Please, they may amend the memo to delete us. That's all. Because the release cannot even be implemented by me. If you see page number 26.
Yes. Okay, I will take it. The petitioner has filed the present writ application challenging the termination and cancellation of the GEM contact number GEMC-511687730825557 dated 11th of January 2023 for supply of 1,18,000 infant weighing scales under the ICDS scheme. ICDS scheme. Full stop. The concept for the petitioner submit that. Submit that. There is a dispute between the petitioner and the respondents, and the petitioner has already initiated the arbitration proceeding before the MSME before the MSME Facilitation Council. And in the said proceeding, the respondent authorities are not appearing or contesting the same. On 4th of August 2026, the petitioner is informed with regard to the proceeding pending before the facilitation committee. And on receipt of the said information communication dated 4th of
Lordship,
August.
can I take Lordship's leave?
Yes, yes. 4th of August 2026, the respondent authorities have passed the impugned order. He submits that as per the impugned order, the communication has been made between the petitioner and the respondent authorities in the year 2024, and lastly on 8th of August, 25th of August 2025. But now only after receipt of the communication of the petition with regard to the arbitration proceeding before the MSME Facilitation Council, the respondent authority in haste have passed the impugned order. The land counsel for the petitioner further submits that. And counsel for the petitioner further submits that the claim made by the petitioner before the MSME Council is rupees 6,51,94,729. Though there is arbitration proceeding, arbitration clause, and the petitioner has initiated the arbitration proceeding before the MSME Council, Facilitation Council, but that will not debar the petitioner to file the present writ application for filing the writ application challenging the impugned order. In support of his case, he has relied upon the judgment in the case of Harbans Sania and another versus Indian Oil Corporation and others, reported in 2003 Volume 2 SCC 107, wherein the Honorable Supreme Court has held that in an appropriate cases, in spite of ability of the alternative remedy, the High Court may still exercise its writ jurisdiction in at least three contingencies. Number one, where the writ petition seeks enforcement of any fundamental rights. Number two, where there is a failure of principle of natural justice. And number three, where the orders or the proceedings are only without jurisdiction virus of act is challenged. By referring this decision of the Honorable Supreme Court, the petitioner submit that without giving any opportunity of hearing to the petitioner, the respondent authorities have passed the impugned order. He further submit that the respondent authorities have passed this impugned order in spite of having knowledge that the petitioner has initiated the arbitration proceeding and the said proceeding is pending, but the respondent authorities are not contesting the said proceeding by appearing in the not appearing in the said proceeding. Per contra, an advocate appearing for the respondent authorities submits that he is not raising the point of
Using code number 10.
concede that the writ petition filed by the petitioner is maintainable. Thus, this court has not gone into that aspect whether the writ petition is maintainable or not. As regard the grant of interim order, the petitioner, the respondent of the advocate appearing for the respondent submits that in the tender documents there are provisions of guarantee, warranties, termination of default, grounds for administrative actions, and other provisions.
And written policy. Written policy. Written policy. That was.
And written policy. Written policy. He has relied upon the minutes. He has relied upon the minutes of the meeting dated 5th of July 2024.
5th July.
It is 5th July or 15th July. 5th July. 5th July 2024. And submit that in the said meeting it is categorically mentioned that the damage infantometer / infant weighing scale already supplied to the district and sub-regional office have to be replaced within next 1 month, and there are several points of interest. And after the said meeting, on 25th of July 2024, the petitioner has informed the authorities that they will lift back the waiving scales and shall be and will be क्या बोला? They will lifting back, informing the authorities that the vehicle for lifting back of the waiving scale shall be reached to the place of the respondent authorities on 1st of August 2024 and 2nd of August 2024 for lifting back the same. And after the replacement will be completed and they will complete the replacement as decided in the said meeting. Then concept for the respondent submit that in spite of the information given by the petitioner, they have not taken back the set and they have not replaced the waiving scale, infant waiving scale, waiving scale, full stop. Full stop. He further relied upon the minutes of the meeting dated 12 December 2024, wherein the petitioner was informed that the payment would be initiated for the infometer and infant waiving scale for which satisfactory certificates have been received from the district magistrate and which CRAC has been generated, subject to approval of the department. In this said meeting, it was also decided that the supplied infant waiving machine, if rejected after negative test reports from CIPET/ILM and the bulk replacement of the rejected devices, if again fails, the testing at CIPET/ILM appropriate action will be taken against the seller, subject to the approval from the competent authority. Full stop. By relying upon the said documents, the respondent submits that the petitioner has failed to replace the materials in spite of attending the meeting and in spite of admitting that he will replace the same. He further submits that once he has violated the terms and conditions and not complied with the minutes of the meeting, accordingly the authorities have no other alternative but to terminate the contact of the petitioner. Full stop. But the learned counsel for the respective parties produce the materials on record. This court finds that the respondent authorities have terminated the contact of the petitioner on the ground that the petitioner has not lifted back the waiving machine which is required to be replaced. Subsequent several requests have been made to the petitioner, but the petitioner has not adhered to the same. The petitioner had the knowledge with regard to the minutes of the meeting. Full stop. Considering the above, this court find that the termination order issued by the respondent authorities is legal or sustainable is to be decided only after exchange of the affidavit. But this court find that in the impugned order, it was informed that the respondent authorities have right to invoke the performance guarantee and also to recover the liquidated damage, and in case outstanding payment, if any, shall be restricted only to the union. Informed that the right of invocation of the performance guarantee and also liquidated damage in case of outstanding due is pending, the authorities will take appropriate steps. This could find that the petitioner has already initiated the arbitration proceeding before the MSME Arbitration Facilitation Council. In the said proceeding, the petitioner has claimed the total amount of 6,51,94,729. Full stop. Considering the above, this court finds that once the petitioner has also raised his claim of rupees 6,51,94,729, and in pending the said proceeding before the arbitrator, and And if the respondents will invoke the bank guarantee and claim the liquidated damage of or any outstanding, the petitioner will suffer irreparable loss and injury. Accordingly, the respondents are directed not to invoke the bank guarantee and to recover any liquidated damage till 23rd of September 2023. The respondents are directed to file affidavit in opposition within 3 weeks. Reply if any to be filed within 2 weeks thereafter. This is the matter on 23rd September.
Lordship, he has to extend the bank guarantee.
23rd September, where is the question?
It is.
Today it is not expired, so till 23rd September, we can't better his right in my petition. My lord, after 23rd September, this because
No, there is every chances, no, Lordship, many time matters are not taken up, Lordship.
March 2027.
Lordship, this is what.
March 27, his right is there.
No, it is 27, March 27.
No, Lordship, I understand. Lordship, but he has
It is already expired.
Respondent number 3, and she submitted, though the respondent number 3 has made a party in the present date application, but no relief has been claimed. In view of the selection made by the counsel for the respondent number 3, this court find that the respondent petition has already made the respondent number 3, and if the respondent number 3 intending to delete her name and delete their name, the respondent has the liberty to take appropriate step for deletion of the name if they are not the interested party or affected party in the present date.
Petitioner, my lord, petitioner may take steps to amend the memo.
Lordship, only thing is, see, Lordship, what I'm saying.
It is 6th March.
No, what I'm saying is, in case for abandoned precaution, Lordship, this is my submission, then Lordship can do, I am in the hand of Lordship. What I said is, he's only what is going on is my time period of invocation. The litigation means if he
until March.
No, Lordship, can you see? So once he is only my invocation period, he can get over by this, any litigation, save out of that. So if your Lordship is protecting him, he should also.
I am not protected. I only stated that the bank guarantee is with you, not to invoke till.
Then Lordship, can you see bank guarantee? I have only some time with me.
Yeah.
Bank guarantee has lapsed.
Correct.
So now what I'm saying is, if he really wants to invoke that protection, he has to also renew that, because if he do not renew it,
23rd will see to it. Come on, 23rd.
Then Lordship can renew, because that day he will say that no, I'm may change determination.
Ekta record kare. Though the bank guarantee is, the validity of the bank guarantee is up to
16th March 2026. 2026.
Where is that?
But that
16 March 2026, but
claim period is.
Where is the bank guarantee?
Yes, madam. I'll just write. This is my lord. My lord will find at page 94. Page 94. My lord will find 90. This letter, page annexure P7. Kindly see bottom of the page. It says claim period is 16 March 27. And if my lord scrolls 3 pages down, my lord will find the bank guarantee itself says, my lord, that is valid up to 16 March 26.
The bank guarantee is valid up to 16 March 2026, but the liability period is up to
16 March 27, my lord.
16 March 2027. 16 March 2027. Thus, the respondent's authorities are restrained for invoking the bank guarantee till 23rd of yes, 23rd September 2020.
Much obliged.
I'm obliged,
Clear?
Yes,
most grateful.
Otherwise, next day it will be there. So Lordship is not granting me that because I have ample time.
Correct.
Yes, Lordship. I'm coming.
Fixed matter, I'm for the opposite respondent, Lord, Eastern Coalfield. On the last occasion, Lordship Lord has permitted me to come back with instructions regarding the calculation of diesel escalation and Lord, whether there is any clause in the contract with regard to liquidated damages. That is my lordship's last order, my lord. Of my lord 23rd July. But after that, my lord, I have taken instruction of my.
Yes, diesel escalation and as mentioned.
Yes, these two. So, my lord, so far as the diesel escalation is concerned, I have got two new documents. One is my lord, the old calculation date and the other is my lord, the new calculation date, both. And my lord, so far as the liquidated debt.
That any matter?
But my matter will not, I'll be anyway not seeking 1 day's time. My supplementary affidavit is ready. I have spoken to my learned colleague on the other side. But and I will also not bring the additional terms of the contract, which includes a clause for liquidated damages. So that these, I will that way will not be able to answer.
Terms has been included subsequently or?
No, terms were there, not disclosed in the liquidation. So not my fault, I also could not disclose. So these I will, my draft is ready. Without Rossi's leave, I have drafted it, but I can't. It has to be affirmed. So kindly give me time to serve upon them the affirmed copy by Monday and any date on Monday, after Monday.
After Monday?
My lord would
Any
kindly-
time after Monday.
My lord would kindly be pleased to, my lord, place this matter as a part heard matter subject to.
Yes.
Because my lord has already heard us.
Yes, Lordship has heard them.
Mr. Kishore Datta has already finished his arguments, my lord. Well, it's written in your lordship's previous order that we have concluded our arguments. Now they are bringing new documents, that's a different thing.
No, those after
let-
the
let-
query has fallen. Query has fallen from court. I have to.
Let counsel for the respondent request for time to bring some document on record according cases certain when.
But by Monday I'll serve and I'll get it ready by Monday.
The petition directed serve the supplement, you will file supplementary.
Supplementary.
Is liberty to file, the counsel for the respondent is given liberty to file supplementary affidavit by Monday after serving the copy to learned counsel for the petitioner. The petitioners are at liberty to take exception to this supplementary affidavit if any will by 21st.
By 21st.
By 21st, list the matter on 24th August under the same heading within 10 matters.
Well, it will be fixed time.
Acha, on 24th within 24th within 10 matters under the agenda. If time fixed, then it will go to September.
My lord,
Not required.
within 10 minutes.
Next. এটা আমার কলেজ কোথায় চলে গেছে? এখানে আছে। All this trend. Okay, এখানে আছে, আচ্ছা। Yes.
Well, I'm for the state. Well, that's served, my lord. I'm going for to. Well, the lordship, my lord, did not go deep into the matter because the prayer which I am seeking is a very innocuous prayer. But there is a background to that. My lord, at page 176. My lord, your lordship was supposed to give me protection by an order on 17th of June. My lord, the relevant portion, my lord, is at page 180, paragraph 15. Finds that if the respondent authority will open the tender on June 18, then issue work order in terms that the work order should be issued to the petitioner on 16th January will be frustrated.
Give effective 15 January.
Till, yes, open the tender will not give effect till 15 January 2027. Now, my lord, this was on, kindly, my lord, see, this was on 17th of June.
Yes.
The my lord, the page 186, my lord, the very next day, my lord, I'm sorry, my lord, no, the page, next page would be 2. 17th, my lord, order was passed. On 18th June, they opened my tender. And upon opening my tender at page 183, they asked for certain documents to be placed, which is a technical evaluation PPO tender held on such and such at 2 p.m. requested to be present. When I was present, my lord, at page 184, my lord, they asked for a photocopy of the license and the income tax return, which is at page 184. My lord, the license which I have given at page 186.
Yes.
Kindly, my lord, see, this is certified renewal of license for the manufacture of blood products. My lord, kindly see the last line, he is hereby renewed with license, is effective from April 26 to March 2031. My lord, thereafter, my lord, 188, another drug controller's license. My lord, same 26 to 31. Now, my lord, I am not asked. I beg your lordship's pardon.
Yes, got it.
My lord, it includes all the, I'm cutting the matter short, my lord. Now, my lord, my impugned annexure is at page 210.
Yes.
My lord, at the lot, your top lordship's fine, 27 July, page 210, annexure P11.
Yes.
My lord, kindly see, my lord, this is the printout of the e-procurement system, 27 July, my first name is there,
Not qualified.
rejected, technical. Then, my lord, there are a series of correspondence starting from pages 214 till 218 where I ask for the reason. Reasons are not coming. And, my lord, what I find at page 228, technical bid was opened, but the financial bid is not yet opened. So today we are in a situation, my technical bid is rejected. The main prayer in the writ is, my lord, asking them to convey the reasons, because this litigation has a background. I had come to court against them, they have suffered an order, that's why, my lord, we want the reasons to be given. Now, my lord, in the meantime, they should not finalize the final bid. And I say this on the basis of, my lord, the tender condition itself, which is, my lord, at page 30. Whoever the technical bid has been, my lord, whosoever's bid has been accepted, my lord, technical bid, number I don't know. My lord, this entire bid validity is valid for 1 year.
Yes.
And in any event, prior to 2027 January, nothing can be finalized. So, my lord, let them not give up, because once they open the financial bid and award it.
That order is not challenged.
I beg your lordship.
The order is not
No,
challenged.
no, nothing.
Not challenged.
Because it's 220, my lord, January 2020, they had made sure that I don't carry on. So, my lord, I think the, my lord, the trend is going that way. So, my lord, I'm left till January, but they will not suffer any prejudice. So, the interim order that I'm paying, not to finalize the tender, till such time, my lord, they give, no, not to give the reasons, till such time, my lord, that.
No, my lord, I have objection to that.
Yeah? Not to open the financial bid.
My lord, actually, your lordship, actually, my lord, kindly see your lordship, previous order, your lordship, at
Yes.
page 176 itself, my lord. But my lord, they have, I think that at that point of time, it was not rightly appraised to your lordship, my lord. Page 176, my lord.
Yes.
First, my lord. My lord, page 177, my lord. Kindly come to, my lord, the fourth line. Discuss the frozen plasma to be January 24, informing that the initially the said work order will be valid for 1 year and may be extended to next 2 years, my lord. It was maybe, so it was subsequently extended for 1 year, then 3 months, then 2 months. So it was not such a bounding duty that it shall be extended. No, my lord, I'm coming.
It's okay. So,
No, my lord, kindly come to your lordships, my
no,
lord.
you have rejected the technical bid. Correct.
Yes, my lord.
So, come with the report why the technical bid is rejected.
But that I'm coming, because your lordship at the last paragraph mentioned that it shall not be.
Correct. That will ask you whether you have challenged this order or not.
No, but we have not challenged. I think that it is not challenged because I received the petition in the morning itself, my lord. It was it is not a fault of them, my lord. So, my lord, kindly come to the page 38, which was the bid, which they are saying it should be like that. But this is the bid, page 38. Page 38. They are saying that the technical bid is open and the financial is. Madam, page 41 point J, the bidder is expected to examine all instructions, form, terms and conditions in the tender document. Failure to furnish all.
From your reading.
Page 41, my relevant part, respectively, I've not wasted. Page 41, just 41. Page 41, man.
Which clause?
Well, kindly come to page 40 first, my lord. Page 40, last point, last D point, my lord.
Yes.
40 point D.
Only qualified technical.
Only qualified technical bid will be considered for opening operation. Yes, but I'm coming, my lord, on that point, my lord. Here also, he's saying that the whatsoever, so J, whether the bidder is expected to examine all instructions, form, terms and conditions in the tender document, failure to furnish all information required by the tender document or submission of a tender, not substantially responsive to the bidder document in every respect.
Which clause you are reading?
Page 41, my lord, clause J, my lord. Which was they are accepted, they applied for as per this contract, they were consented to this. Respect will be bidder risk and shall subject to rejection of the bid. Now I'm coming to the only relevant, I'm not wasting your lordship's time, my lord. Now kindly come to page 43, my lord. Page 43 of that, my lord.
No, that's correct, sir. The query of the court is that naturally you have rejected the technical bid, no problem at all.
Yes,
correct.
Yes.
Financial bid is to be open after the technical bid. It's no problem. That is
Subject
settled.
to also qualified by the technical. Yes, my. Yes,
Correct.
my.
Correct. But now only the question you have online, it has been given that the technical bid is cancelled.
Yes.
Because you, after the technical bid is open, you have asked for certain information from the petitioner. Petitioner has furnished that document. Correct. Petitioner furnished the document. Now you have terminated the rejected the technical bid. If you rejected the technical bid, then let you file the report. Why the technical bid is rejected?
That is my one of the mistake is already admitted by them.
Show me.
My lord, page 213 of this petition, my lord. One of the mistake, and your lordship, this is the technical bid. They're demanding personal hearing and the detailed reason. It's not some.
They may ask several things. They may ask your total factory.
Yes,
but if the court is asking something, must is required for the adjudication of the court.
But technical process, my lord, if you must start giving page 213, my lord. Page 213, which they are, this is second email by them.
213?
Yes, my lord, page 213 of the petition. Dear sir, madam, second email. It's greeting of the we sincerely apologize for the inadvertent error in our earlier email due to oversight. The income tax return of the 2020 was attached instead of the requested this, which please find attached. But these types of mistakes, my lord, if we keep on continuing to address the reasons, my lord, even a small short of mistake is enough for rejection, my lord.
That's why you indicate, come with the 2-line report. What is the condition? Why the technical is rejected? That's all. If this court finds, yes, he has not qualified in terms of the technical bid conditions, nothing else.
Yes, my lord. I shall.
Because you have informed the petitioner to supply so and so. He has supplied it.
Yes,
subsequently, you are not satisfied that you have cancelled and rejected that. Once you are rejected, now they want file the writ application. So okay, file the writ application. Come with the when you tomorrow, day after tomorrow, only you have to show the writ.
That is my only minute.
Tomorrow and Monday or Tuesday.
Well, Tuesday, kindly.
When the financial bid will.
But there was no such thing as that. In the morning, I received it, my lord. In the morning, I received the petition. I have yet to contact the department. What I've gone through, I understand. I made submission.
When you will come?
Well, Tuesday, your lordship. I know already your lordship has given the protection in the previous order up to that. So no protection is needed further, my lord.
Correct. No, but you find out. But the problem is that if the technical bid is rejected, he cannot participate. His bid will not be considered.
Only 15 has asked. This is 2 holidays. No one is going to come. My lord may keep it on Monday. My lord.
Okay, you take care of this.
Yes, my lord. I shall.
Correct. Come on Tuesday.
My lord, I shall be grateful. I shall.
This could the petitioner is being agreed and has filed the present writ application being agreed with the rejection of the technical bid. The counsel for the petitioner submit that by a communication dated What is the date of the 30th July?
210, page 210.
Huh?
213, my lord,
No, it's 210, my lord, which is impeded order. They are challenging 210, my lord.
By a communication dated 27th of July, not communication.
27th July.
27th of July 2026, comma, the commercial, the technical bid of the petition was rejected. It's rejected. The petition submitted though the technical bid, before the rejection of the technical bid, comma, the respondent authorities have made correspondence with regard to supply of certain information and the petition has supplied the same. But in spite of the same, the technical bid has been rejected without assigning any reason. He further draw the attention of the, he further submit that though the technical bid is open, but the financial bid has not been open. Accordingly, he prays for a direction upon the respondent authorities to bring on record what being on record with regard to the reason of rejection of the technical bid of the petition. Learned Counsel for the respondents prays for time to bring on record to file report to place on record before this court with regard to the reason on which the technical bid of the petition was rejected. Accordingly, case is adjourned till 18th of August 2026. The respondent is directed to file the report assigning the reason for which the technical bid was rejected of the petition is rejected. This is the matter on 18th of August within 10 matters under the same heading.
Highly grateful. Highly
Page 230. I'm sorry, I pointed out the previous page. My learned friend, he says that he doesn't have instructions, but page 230 is the printout. Your lordship has it?
Yes.
Milord, at the bottom right hand corner, your lordship will find 10th of August 2026. Till that date, Milord, it is opening in progress. So, Milord, if it is in progress, and if it comes on 18th and says that it's open, Milord, then what will happen? What will happen is this, Milord, once the final bid comes up, Milord, then everybody comes to know what is the competitive price. Let them not open, or even if they open, let them not publish.
In that case, my lord may keep it on hold.
Let them not open. If they are not open, let them.
No, that thing, my lord, that is the type of injunction order of this upon the. My lord,
That's why because till date the financial has not been open.
This is in such a way, my lord, kindly consider, my lord. So we are not going to open. I just going to communicate them. My lord, on a.
So I am.
Yes, my lord.
The report is relied upon your submission.
But today something has been happened, my lord.
And this is the apprehension that I was coming.
Today, my lord, just
he will come and say that, my lord.
The Learned Counsel for the petitioner respondent submitted on instruction that till date they have not opened the they have not opened the financial bid. Let in view of the submission made by the counsel for the petitioner, let the matter appear on 18th.
My lord, I'm getting.
Respondent. I am showing evidence. Obliged, Milord. We'll come back on 18th.
Item number.
Yes, who is for the petitioner?
145.
None appears on behalf of the petitioner. WPA number 9708 of 20.
145.
Withdraw.
None appears on behalf of the petitioner. No recommendation is sought for.
Arey, tomar
My lord, 145, I would want to withdraw, my lord. I am submitting, I would want to withdraw.
Learned Counsel for the petitioner prays prays for withdrawal of the writ application according WPA number 9708 of 2026 is dismissed as withdrawn.
I'm grateful. I'm grateful.
Does I have to sleep?
146.
None appears on behalf of the petition. No recommendation sought for dismissed.
147.
147, my lord. I am for the petitioner. This is my affidavit of service.
The page number ball.
Page number 37.
Allowed. Disposed of.
Restrict.
Scanned copy.
148, I am for the petitioner. My lord, the petitioner name has been deleted, preferred an appeal. My lord has directed to dispose of the appeal as soon as possible. During this interaction, my lord, petitioner has filed for a passport, my lord. And the passport is saying, your file will be closed. My lord,
Your Lordship, liberty may be granted for the passport.
he's telling that the appeal is disposed of. My lord, appeal is disposed of. My lord, the passport is saying your appeal is disposed of. So what remains? But my lord, the passport. Your name is included. My name is. So go and file an application for the review. How this order will be. My lord, the passport is saying my application will be closed. My lord.
He is seeking direction against the passport authorities.
How two prayers will made here? My lord, kindly see the PR number. What?
Prayer.
How the two prayers can be made? Of the different authority? My lord, only kindly see on the PR number D, my lord. PR E, my lord. PR E. At page 17, my lord. So what you want? My lord, direct the passport to apply the passport. You got the order in favor from the appellate authority. My lord. So what requires further? You go and give the order before the appellate authority, file an application, automatically it will be reviewed. What further? Appeal, my lord, appeal has been dispensed, my name has been enrolled.
He has already, his application for renewal is pending. He is seeking prayer that it may not be closed. That's all against the passport authority. This is his prayer.
He got the appellate order.
He has got the epic card.
Then why you go and appear before the passport authority? I have applied, my lord. Passport authority is now saying
হ্যাঁ তো আর কতদিনে বন্ধ হবে ওটা বল ক্লোজিং ডেট আছে তো বাকি
closing date is 27th August.
হ্যাঁ তো অনেক সময় আছে যেটা জমা করে দে ছেড়ে দে
The petitioner submit that this name has already been included in the voter list in terms of the order passed by the appellate tribunal. Accordingly, the petition is disposed of.
Dismissed.
Next.
The lordship, the relevant page is page number 99.
Disposed of.
150.
Lordship, for the petitioner, the relevant page is 16.
Disposed of.
151.
My lord, for the petitioner, page number 17.
Disposed of.
152.
My lordship, it is disposed of matter.
The writ petition become infectious. Dismissed.
Disposed of.
Next.
2.
153 হয়ে গেছে তো
153, I am for the petitioner. Appeal at page number 38.
Disposed of.
The shop party. 154, my lord, I am for the petitioner. Appeal is at page number 31.
Disposed of.
I am for the petitioner. Appeal at page number 40.
Disposed of.
My lord, according to the last order dated 7th August 2026, the matter was supposed to appear on 21st August 2026. It has been wrongly listed today.
Who is for the petition?
Yeah, my lord.
Where is your appeal? Get the.
Well, here the petitioner is still under adjudication. Well, they are supposed to file a report before your lordship. On 7th of August, it was taken up. Your lordship directed the matter to come on 21st of August. Today is 14th, well, it has wrongly listed.
No. By which order?
Well, 7th of August, lordship can consider.
Okay, so where is the order? You are not uploaded here.
This is the order.
तो ऑर्डर नहीं पढ़ते ना 21st August.
Obliged.
Yes, next.
157, my lord, relevant page is page number is 27.
Disposed of.
158.
My lord, page number 28.
Disposed of.
159.
My lord, page number 47.
Disposed of. Disposed of.
161.
The relevant page is page number 72.
Disposed of.
162, my lord, I am for the petitioner. Relevant page is page number 32 is the relevant. The affidavit of service may be kept.
Yes. Next.
163.
No affidavit, we keep with you.
Page is 20.
Disposed of.
164.
Page 20 lordship.
Disposed of.
Page 22, Lordship.
Disposed of.
Page 19, Lordship.
Disposed of.
Lordship.
My lord, page 25,
Disposed of.
page 62.
Disposed of.
Page 34.
Disposed of.
My lord, page 61.
Disposed of.
And copy.
Disposed of. Disposed of. Disposed of.
I am for the petitioner. I am for the petitioner, page 20.
Disposed of.
I am for the petitioner, page 20.
Disposed of.
Here, huh?
Disposed of.
Lordship, I am on behalf of the petitioners. It's from page number 34 to 44.
Family members.
How many? How many petitioners?
There are 5 petitioners, Lordship.
Who are they?
Family members.
How family members?
Because it's from the same lineage that their parents' record were there in the 2002 SAR, Lordship.
Huh?
Their parents' record were there in the.
How
Same or same.
All fathers' name are same.
All fathers members.
Yes.
Disposed.
All are daughters.
Have paid.
One son and four daughters.
How paid the court fee?
Court fees দিয়েছে?
Yes.
জনের জন্য?
Yes.
Dispose of. Next.
স্ক্যান কপি পাঠাবো।
ঠিক আছে। এই নাম্বার
বলেছে অলরেডি।
ডান
200 কটা 222 দিয়েছে?
হ্যাঁ।
সবার জন্য 222 করে দিতে হবে।
আচ্ছা ঠিক আছে।
By that, I on behalf of respondents,
Who is for the petitioner? Yes. You are recommended candidate of?
My name was not considered.
The petitioner name has been recommended by the school which department? Recommended by? Where is the document? Which page? The name of the petition is recommended by the West Bengal School Service Commission for appointment of teacher. But whose name has been deleted? Petition name is deleted. The name of the petition is deleted from the voter list. But due to which the petition is not in position to submit the documents, and the authorities are not considering the request of the petition. He submitted the petition, already prepared an appeal before the appellate tribunal and prayed for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner. The appellate tribunal is requested to dispose of the appeal filed by the petitioner dated 7th April 2026 as early as possible, preferably within a period of 2 weeks from the date of receipt. Yes. Next. 180. None appears, dismissed. Where is the same means? He is also selected candidate. Same order.
চলে যাও বলে দেবো।
Next.
বলে দেবো।
Not even same. Yes.
Lordship, it is, I am for the state lordship. It is not an SIR matter, Lordship. This is a same matter was filed by the petitioner's advocate on the same cause of action before your lordship. It was appearing and subsequently it was released and it was appearing before Honorable Justice Shobhata Bhattacharya.
SIR में क्यों लाया?
Lordship, they have seeking protection.
हाँ, लियो SIR का थोड़ी है। ये तो वो है वो जो पूजा के लिए परमिशन वाला है।
Yes,
They are seeking
permission.
police protection, Lordship, and
Not police protection. There is no police protection. Give.
peaceful entry.
Give. तुम लोग भी देखते नहीं अनपढ़ लोग की तरह काम कर लेते हो.
Lordship, I am led by Mr. Rajdeep Majumdar, the learned AG, in this matter.
Yes. Why you are not allowing the petitioners to perform the Mansa Puja?
Lordship, police is rendering protection, Lordship. There is the private respondents are not appearing. Whether they have been served, I am for the state, Lordship.
Yes, my lord.
I am appearing representing the police authorities.
Where is the representation?
My lord,
Representation টা কোনটা বলুন?
my lord, page number 14 and 15, my lord.
14 and 15.
I have given representation to the municipality and to the police as
Police
well.
authorities and
Police authority, how this got done? Last occasion also told.
My lord, I know, that's why I have given it to the municipality as well.
So you have already moved the writ petition, go to the other court. Why you are
My lord, I have
Lordship, the matter was appearing as item number 1 today before Honorable Justice Shogoto Bharsaj.
But my lord, but
What has
there,
happened?
Lordship, he couldn't show the service properly, so it has been sent to monthly list of September.
Good. Yes.
my lord,
ওখানে কি একই কজ অফ অ্যাকশনে ফাইল করেছেন?
I seeking their police protection, my lord.
For registration of FIR, Lordship. The only slight change is that for registration of FIR.
And protection I need there, but
What you want?
my lord, I need permission to enter and perform the puja, my lord.
Where?
In the mandir, which was situated.
Restraining you.
The private respondents.
The private respondent is saying how the writ court can entertain.
A title suit is also pending, Lord.
My lord, the title suit is pending. There is a in the injunction. The respondent number 6 and 7 are no one.
Have you served the notice to the other party?
Yes, my lord.
Where is the affidavit service?
আমি এক্ষুনি দিয়েছি।
রাস্তা দেখুন, আপনি দেখুন।
Service complete হয়েছে?
Their advocate who was appearing in court number 5, they have received that. My lord.
Advocate have received. You have not served to the party. Come on Tuesday.
আবার সার্ভিস করে আসবে।
সার্ভিস করতে বলছেন জজ স্যার।
Private party.
Main में Tuesday कर दे. Yes. Next.
Grateful, Lordship. 183.
तो लीव लिखना ना. Who is for the petitioner? None appears on behalf of the petitioner. No recommended sought for. WPA number 21370 of 2020 is dismissed.
34 is not a SIR matter.
84 my lord, 184 not SIR matter. This matter, your lordship keeps the matter on 19. But Thursday I
करते रे बाबा तुम लोग. सब लीव बोलने से सब ऐसा हो गया. 19 को रखो लीव मैटर है. Note it. 19th August.
recess.
This
my lord.
is the-
Yes, ma'am.
Ah.
The issue was something else in that.
What?
My name is recommended.
Ah.
Now I had OVC certificate.
Ah.
Now in view of the circular issued by the OVC department,
Ah.
now that it has to be verified from the date of verification by the service commission.
Hmm.
That is scheduled on the 17th.
Hmm.
That unless if not in the meantime that
So what will happen on 7? Because if the court pass an order, what the appellate authority will not be able to dispose of 7
as
days.
well that in other matter, when the Russia is passing orders, I have my sample copy
Ah.
that temporary verification order may be passed subject to the outcome of the appeal.
Hmm.
That order will not help us.
Verification.
It's a procedure that I have.
Hmm.
The circular is that if the appeal is names deleted from the electoral, that all certificates.
Since not appearing in the matter is called. Why the advocates are not mentioning? The advocates who are mentioned, I have passed the order.
I ought to have been there, I was
No,
not.
you not. Somebody has mentioned that somebody was there, but nobody is mentioned.
Our
You have
mistake.
mentioned 2 matters. You have passed an order.
My lord, just now, thereafter, my lord, I'm telling their ask,
But one line will kindly see this because of this line.
What?
Because of these last 2-3 lines. Because of this circular, we are in difficulty. Issued by the other record class department. Temporary certificate will serve my purpose.
Yes. So what happened?
Only temporary for the timing for the purpose of verification, subject to outcome by the appeal.
Which matter? Sir, item number?
179.
একটা record करो 179 ना একটা record करो the you have made a party, authorities are party.
Yes.
Which respondent?
SDO is the competent authority to re-verify the document. And
who authority? Which authority is this?
Sub-division officer is the authority who is to.
No, sub-division officer is not the authority.
Yes.
Backward classes and welfare department.
Six. Six may be directed.
Item number key 179 to
179.
And the respondent number 6, comma the secretary, comma West Government of West Bengal, comma backward class welfare department is directed not to cancel the caste certificate of the petitioner till the disposal of the appeal filed by the petitioner.
Extremely good. Re-verification that should I order this?
Published.
ठीक है
उसमें ऐड कर देना जो डिस्पोजल बोला ना डिस्पोजल से पहले उसमें कर देना
Grateful.
ये 179 ही बोले हम ही क्या तो बोले नहीं यस फिक्स नहीं है September monthly list.
My lord, Mr. Jayanta Samant is for the petitioner in this matter. He is on legs before court number. Kindly grant short passover.
Passover.
Grateful, my lord.
October 26 monthly list October.
But 14 for the petition.
Although there was a direction upon state government my lord, to file a report.
Yes.
My lord, it
My
is
lord,
the
but-
matter regarding the disability, my lord.
Yes.
My lord, that the person was
person after my lord examination was found 70% locomotor disability without my lord there is any chance of my lord improvement. And despite that, my lord, the temporary
So is for the state.
my lord, state was here, my lord.
My lord, I am for the bank.
She is coming, my lord. My lord.
My lord, we have rejected it. My lord, kindly seize the disability certificate once, my lord.
My lord.
Page number 45.
Our disability certificate, my lord.
Lordship, there are three certificates. This was produced to the bank.
No, I will check it.
Yes.
Lordship, if I may show, your lordship will see the contention. This is to certify that I or we have carefully examined Sri Aniket Kumar Singh, my lord, who is the petitioner, son of such and such, dated 21/7/1999, male, registration number, resident of such and such, whose photograph is affixed above. I or we satisfied that he is a case of locomotor disability. The diagnosis in this case is, my lord, something written, my lord, left in hip joint. He has 70% in figure, 70% in what's temporary disability in relation to his hips. My lord, nowhere his certificate says that it is not likely to improve. My lord, for that is the reason, my lord, the bank could not consider. Now, if your lordship kindly sees, my lord, the notification which they are relying upon, your lordship. The lordship will see the last.
The bank, what?
No, my lord, that is not the case.
Lordship, we have rejected, we have given him two times occasion, my lord, when he can submit a certificate showing that his disability is permanent. My lord, he couldn't produce that. The certificate which he has produced has said that it's a temporary disability. And my lord, he has applied for the category of, my lord, permanent disability. That is the reason for our rejection.
This is something somewhat different, my lord. So for the diagnosis sheet is concerned, my lord, kindly come to 47. Based on which the certificate was issued, my lord. And also, my lord, the second certificate. First, my lord, kindly come to page number 44, T7. 44, my lord.
Yes.
My lord, this is the disability certificate test based on which the certificate was issued. Your lordship will find 7, may I read, my lord? The medical board recommendation, your lordship will find disability percentage, 70% disability condition, not likely to improve. It is absolutely categorically, my lord, found there. Then nature of disability, however, was stated as temporary. Although I would, my lord, take your lordship to the particular notification where it has been stated. Now, subsequently, my lord, when our first application was not document verification or rejected, we again went to MR Bangur, my lord. There also again the test was conducted, and my lord, your lordship will find that, my lord, page 58. Page 58 your lordship will find. We also submitted this one. Your lordship may read. It is declared that the disability of the above person is recommended for 9 years, 9 months, but in the future his disability percentage will increase.
Yes.
So, my lord, absolutely there is no chance of my disability being, my lord, reversed.
Yes.
And despite that, my lord, my
so what is your prayer?
My prayer is that, my lord, when we approached the PNB bank, because, my lord, my offer letter was issued, my lord.
What?
Offer letter for the post of, my lord, clerical post.
He appeared in IBPS examination, my lord. Thereafter, he was selected.
Under the disability category.
Under disability category, absolutely. Under disability category, we appeared, and, my lord, we find that.
Who is appearing for the state? Yes. What is your
My lord, my
instruction?
My instruction is, my lord. Said disability always has a chance to improve. Disability always has chance to improve or deteriorate in future. So that case, percentage of disability will be changed. In case of issuing a permanent disability certificate, there will be no chance of reassessment.
Why? Disability certificate, it is to be given for the 5 years or 3 years. If it is given the 3 years or 5 years, then it has to be reviewed.
Reviewed, right.
My lord, in case it.
Who has given this letter?
Respondent number 4, my lord.
Respondent number 4. He is having the knowledge of the No. Kindly come to the page 58 as your authority has considered page 58 before issuance of this instruction or before placing this instruction before this court. Have you considered? This is the way the authority is functioning. See, read 58 and read your instruction.
My lord, as there is a term of permanent disability.
Read 58 loudly.
It is declared that the disabilities of above
The above said person is recommended for 9 years, 9 months, but in future his disability percentage risk increased. Where is the question of decrease? And how this superintendent has given this?
And my lord, if your lordship kindly comes to notification, there is, my lord, absolutely government notification to the extent, my lord, kindly come to 59.
Yes.
This is the notification issued by the government disability Department of Empowerment of Disability. My lord will find this was issued back in 20th January 2024. My lord will find that issue permanent disability certificate. May I read? Number 1. Issue permanent disability certificate in case where there is no chance of improvement over the time of degree of disability. It is categorically mentioned. And also, this implies that the cases of disabilities that are progressive, non-progressive,
if the person is suffering from a 70% disability, what you are playing with the disabled person? It is not a 40%, 35%. It's a 70%. And your authority is assessing that. And now the superintendent has changed the total scenario.
My lord, according to his version, as the term is permanent disability, so there will be no change of.
Correct.
But in case of
how the superintendent, where is the medical board?
Yes, ma'am.
Where is the medical? You know how the disability certificate is to be issued? Huh? How many members consisting of the board? 7 members. So
My lord,
whether without the board recommendation, can superintendent give this letter? Tell me, take instruction when the board will be conducted and examine this petitioner. When?
15 days.
15 days. Come Tuesday with the instruction when the board will be constituted to examine this person with regard to the permanent disability or the temporary disability, and to submit the report by
my lord, kindly give some time, my lord.
Why?
At least 1 week time, my lord.
Huh?
1 week time, my lord.
No, I am giving Tuesday to ascertain when the board will be constituted.
My lord.
Because there are minimum 5 board members is required. So come on Tuesday when the board will be constituted. Then the matter will be referred to the board. Then the board will examine with regard to whether it can be temporary, or because percentage is there. The only question is whether it is a temporary or it is a permanent.
My lord, may I on my lord, even if the notification
that is the last line, it has been changed, that permanent disability may be changed, my lord.
Then you come to the notification.
Notification, yes.
Come to the notification. What the notification say? If you are having doubt that it may change in future, then you have to give for the specific period, 3 years or 5 years, with the rider that it will be reviewed for after 5 years. The certificate will be valid for the 5 years.
Well, here the certificate was given for 9 years, Your Lordship.
Yes.
There was a specific time period given.
The time period given.
Given. And Malad, the next one says that not likely to improve, so he will be getting benefit after 10 years. Malad, I bow down to that. Since there was a time limit, Your Lordship, as for the notification also, Your Lordship will kindly see, Malad, the second clause, issue a certificate of disability card indicating the period of disability in case where any chance of improvement over the time in the degrees of disability.
Correct.
That is why, Malad, a temporary certificate, well, I'm not saying that he is temporarily disabled. Well, whatever we have found.
But no, I am telling where certificate, where is the opinion of the board?
Lordship, it is not there. Lordship, I bow down. Lordship, I bow down.
Civil certificate is to be issued by examining the
Yes.
person by the board.
Yes, my lord.
And the certificate should be consisting of the photographs of the person and
Yes.
which place the disability
Yes.
that is to be indicated.
Lordship.
And the percentage is to be indicated and a review after 9 years, 10 years, whatever
Yes,
it may be. Where is the disability certificate board?
Lordship, will see at page number 45.
What?
45 is a disability certificate.
45.
45.
No, go to faster.
My lord, this is the first one. Thereafter, there was another disability certificate.
Where is that?
There was an endorsement. Yes,
That-
my lord, endorsement, not a certificate, my lord, which my learned senior friend just shown, my lord.
We had to appear there on the basis of their instruction. They are not accepting this. Despite the ministry's categorical guideline, if it is not likely to improve, they have to accept. And Milord, subsequently, after this case has started, Milord, your lordship will find.
My lord, only one disability
they have this IBPS, Milord. Now they are accepting, Milord, that not likely to improve.
Where?
Hey, this is the advertisement of
the second one.
My lord, this is the latest one. They have.
Well, the second disability certificate, your lordship wants.
No, I'm on that. This is the guidelines they have now. After this case started, my lord, because the notification was back in January 2025, they were not accepting.
No, this when you obtain this is December 2024.
Yes, but thereafter no disability certificate. Thereafter an endorsement.
When the notification come into force.
Notification, my lord, they rejected my application. My lord.
Just a minute, sir. This notification when
first notification, my lord, was on January 2024.
Which one?
That first notification, page 14.
This which you have given.
But this one is not new. Their recruitment, we gave the advertisement. This is new one.
There.
Yes, that is what I'm saying. They are now accepting.
Who?
After this
IBPS, who conducted the examination.
Now IBPS is now has to accept because there was the solemn guideline. After the filing of this case, now they are accepting, my lord.
Who?
This IBPS. Kindly see the page 10, my lord. Page 10, guidelines in respect of PWBD candidates with temporary disability in terms of such and such a policy, 7th December.
Notification date.
Yes, if it is progressive, non-progressive, or not likely to improve, not likely to.
My mind was not likely to improve, my lord.
So that's why not likely to improve. Then it should be a permanent.
Yes.
So that's what where is the opinion of the doctor?
That is
mentioning the temporary. How it can be?
My lord, even this is saying even if temporary disability certificate, if it is not likely to improve, it has to be considered as permanent. That is the tax of the notification was there. And my lord, your lordship will also find are now covered, that is stated in January 2024, my lord. Page 59, if your lordship wants once more, my lord, page 59, the notification, my lord. The third paragraph, this implies, my lord, after setting out the thing.
The page 59 says that the permanent certificate in case where there is no chance of improvement over the time of the degree of disability and the issue certificate disability card indicating the period. Okay?
Yes.
That's why now here. So
my lord, after that
has been given the page 40. You are harping upon page 49, 45. That is your, that is your
My lord,
disabled.
my lord, initial.
Disabled certificate has been given on December 2020.
My lord.
That has been given a 70%.
My lord.
And it has been given a temporary disability.
My lord.
Correct.
That is what I'm saying, my lord.
Where the petitioner was appeared before the board, when the board was constituted.
My lord, we appeared, just a second. My lord, that is 30th 12 2024. That is page 47. Your lordship will find. That is the doctor's diagnosis sheet. That is on that day we appeared, my lord.
Which page?
My lord, page 47, 44. 44. That is where it has been written. On that day we appeared. Medical board recommendation. This is the recommendation of the medical board, my lord.
Yes.
But nature of disability is temporary.
No, the medical board.
Lord, contradictory.
On the basis of that.
Please see 44. C44. No, medical board recommendation. Disability percentage 70. Last C. Disability percentage 70. Disability condition not likely to improve. If not likely to improve, then
nature of disability temporary.
That's why. So if then you come to read the page notification.
Notification, my lord. Yes.
Page 59.
59.
Now page 59. Bullet point, issue permanent disability certificate in case where there is no chance of improvement.
Yes.
Then you're not likely to improve. Got it?
One more point, my lord. May I humbly, my lord, on this particular page, the notification, may I read for once. This implies that the cases of disabilities that are progressive, non-progressive, non-likely to improve as were specified in the rules are now covered under permanent disability category. Then, further, as per DOPT guidelines, temporary certificates are not eligible for reservation benefits in promotion. Since reservation benefits are not the same ground should also be for appointment to relate to. This is the problem. That is the main issue. They had to have issued the permanent certificate. Now that is why we not subsequently.
The grievance of the petitioner in the present writ application that the petitioner is suffering from 70% disability. And the case of the is diagnosed, and the petition is diagnosed with sequel SEQUALD of CDH within bracket LT with osteoarteries 45 left hip joint. The authorities have issued the certificate on 30th December 2024 with 70% disability as temporary disability. But in the diagnosis sheet, it is mentioned that disability percentage is 70, disability condition inverted comma not likely to improve, but nature of disability is recorded as temporary. The notification dated 20th January 2024, it is mentioned that issue a permanent disability certificate in cases where there are no chances of improvement over time in the degree of disability, or issue a certificate of disability card indicating the period of validity, in case where there is any chance of improvement over time in the degree of disability. The petitioner also relied upon the certificate issued by the orthopedic surgeon, wherein it is mentioned that it is declared that it is declared that the page what? Page 58, it is declared that
What, my lord?
what is it is declared?
No need, my lord.
Huh?
No need, my lord.
Yes, it is declared that
The disability of the above said
the
person
disabilities
Of
of above said person
is recommended
recommended
for 9 years,
9 months, but
in the future,
in the
In
the
his
future his disability percentage
will
risk
will increase.
will increase risk will increase, so he will be
more benefited after 10
more
years.
benefit after 10 years. Full stop. This court failed to appreciate that once the doctors diagnosed that the petitioner is suffering from 70% disability and not likely to improve but how the disability certificate has been given as temporary. In considering the above, the respondent authorities are directed to immediate constitute a medical board to re-examine the petitioner with regard to the disability, with regard to the percentage of disability and whether the disability of the petitioner is permanent in nature or temporary in nature. After constitution of the board, report be submitted before this court within a period of 3 weeks. Let the matter appear on let the matter appear on 7th of September 2026
September.
for submission of report by the medical board.
My lord, only one thing, my lord.
Yes.
My lord, only one thing. If your lordship kindly, my lord, also instruct that not only permanent temporary, but also whether likely to improve. That one, my lord, likely.
And whether
Huh.
the disability suffered by the petitioner is likely to improve or not.
Most of them. Grateful, my lord.
My lord, only the state.
The petition is directed to comply to communicate this order to the medical to the who will constitute.
My lord, the state authorities will constitute for the respondent number.
The respondent number 4.
Two,
To the respondent number 4 for constitution of the board and submit the report.
Time, my lord.
Yes.
Any time fix, my lord.
Come on that.
My lord.
Grateful, my lord.
Any time, my lord. Any time, my lord.
Within 10 minutes.
Grateful.
Yes, next.
Grateful. ठीक है my lord যেমন বলে grateful my lord.
And 15 I am for the petitioner wallet and 16 is my lord.
We have taken out a writ petition challenging the self-same notice, which is, my lord, also impugned in the other writ petition. My lord, so far as our writ petition is concerned, my lord, we have, despite my lord, my learned friend appearing for the petitioners in the first writ petition, had pressed that we should make the first petitioners in the first writ petition as parties. It is our case before lordship that they are not necessary or not even proper party to the proceedings. So, my lord, I subject to whatever your lordship may, my lord, if your lordship hears my writ petition first and decide on the locus, then, my lord, I think it's you.
My lord, the entire proceeding was initiated on the basis of my complaint. Now, my lord, thereafter a notice of hearing was granted. I was willing to participate in the proceeding. Now, my learned senior friend has filed a writ petition challenging that same notice. Now, my lord, if he succeeds in this writ petition, then only the second part will come. If he don't succeed, then whether I will participate or not, my lord, thereafter
My writ petition has to be heard.
Yes. So let my learned senior friend proceed, my lord.
Your writ petition is
16, item 16.
Item 16.
17068.
Who is for the other side?
I am in the first matter where Mr. Chakraborty has filed the writ petition.
No, second.
For the government. In the second writ petition, we have served.
Who is appearing?
Because state would be the answering respondent.
Is the answering respondent
In this matter.
Where is the state? Yes, Mr. Chakra.
No,
Mr. Chakraborty is with me.
No, I am identifying him as a state.
Mr. Chakraborty was engaged as the additional government.
No, senior government.
Chup kar. Then he came to us that I don't want to do this. Only you do that. On the next day he resigned. It's very busy, very good, very. It's a privilege to have his assistance.
So if the receipt is not there, how the matter?
Well, what we can do, my lord,
We have to bring them.
since my learned friend is already appearing for the state in one matter.
দেখি না কাকে engage করেছো দেখি না। Somebody must have been engaged, not will come with the kindly keep this, আমরা জেনে আসবো কি আছে।
তিনি আরো দুদিন যাবে।
But then kindly keep it any day after Monday, my lord. Monday I have some difficulty.
Petition has filed the affidavit of service उसमें आएगा WPA 9847. WPA 9847. Petition has filed the affidavit of service, but in spite of service of notice, none appears on behalf of the state. State. According petition directed to from the next date of hearing to the office of the government pleader, so as to enable the government pleader to engage the penal lawyer to appear in the matter. It is made clear that on the next date fixed, if none appears on behalf of the state authorities, the writ petition will be taken up for hearing in the absence of the watchful state authorities. Let the matter appear on 26th. 26th.
May it appear within first 10 matters. May it appear within first 10 matters. Mr. Mojumdar will never say a no to that, because Mr. Mojumdar is always eager to do the matters.
Yes, come on.
First 10 matters. Kindly, on 26 first 10 matters.
26 is a holiday for us.
Holiday.
আমাদের ক্যালেন্ডারে ছাপা
That's why I fix the holiday then.
But in the bar association calendar, it is marked as a holiday.
First 10 matters. Mr. Mojumdar is always on.
28.
Let the state come. Let
it first 10.
Sure, state will not come.
State will come. State will not come.
Sure, but you want, I will give in writing.
But it will.
State will come.
State will come. Mr. Chakraborty will arrange for one.
Yes, next.
Lord, in fact, I have spoken to the government. Now it's regularized. Almost regularized.
This court, no. I am telling you, today morning also, nobody was there.
This is a very key court, man.
Nobody is coming here. Either worrying about not intending to appear before me.
Under the same heading, under the same heading. Great.
I was thinking that let him be here.
That's why I am telling. I am identifying as the government.
Get the best possible assistance.
17 my petition let.
Yes.
Please kindly state with external page 51.
17 my lord, I am appearing.
For the kidney transplantation, that for that there is a board. That this board has held a meeting. That kindly take some next page 53. My name is appearing I said number 25.
Yes.
Nothing status I
My lord, we have sought for the instruction from the.
Let me have a copy of the report so that I can.
Kindly see point number 9.
Co-passenger, as co-passenger. Also co-worker under the agency like
documents
sector not produced even after the reasonable time.
That is not the requirement of law also.
Donor's wife also donated kidney 1 1/4 year. Not beyond the reasonable doubt. Yes. So how we are connected?
But
how the relationship? Okay, not a real near relative, but
no, it's not a real near relative, but person is known to me through a third person led. But on similar circumstances, your lordship person order can you see the same point was taken, paragraph 6. Is this your lordship's order? But though it was not informed formally, still not just now.
Yes, I know. subsequent new judgment, my judgment has not gone through.
No.
Have you gone through the CD? Where is the CD? Where is the pen drive recording of the evidence of the donor and the recipient?
We have that.
Yes.
We have.
Well, at least not there is nothing on record.
Verification committee is very dangerous. In two of my judgment, I have recorded that. Your verification committee, one doctor is there. Its interpretation is very dangerous.
As per the instruction I have saw, they have only.
That's why he is telling that, na. Though I wanted to see what is the
That will help us.
Yes, my
that
lord.
is, if it is correct, then they will be out. If it is not correct,
If there is a financial transaction proof, then
no, not financial. See, as per the judgment of the Supreme Court and other high courts, it is if you are not the near relative, it is the burden of the donor and the recipient to prove that. It is on you to prove that. Okay, not in a friendship. Friendship, okay, there is no photograph, but how connected? That's why the videography is required. What evidence, what statement you have given before the verification committee to establish the relationship.
Well, your lordship,
Because financial cannot be
until
it is proved that your business.
Yes, I follow your lordship.
But with regard to the how you are related, so that has to be proved. If it is not a near relative.
I understand the very objection of this. The only thing that just now I have received this, your lordship needs to look into the video, or your lordship can.
Now you do one thing. When you will bring this pen drive,
that can be done.
Pen drive, I will check it. Then if it is correct, then the order will be passed. If it is not, then it has to be remanded to the authority.
Yes, your lordship can remand it, framing a guideline that this has to be ascertained.
Let me see what is the statement recorded.
When? 1 week time.
1 week time.
Next week.
The petitioner has and the respondent have submitted the report wherein it is mentioned that any evidence in support of their friendship as co-passenger as well as also co-worker under an agency like photographs etc. is not produced by even after reasonable time period from hearing. Whether the total evidence which has been recorded by the verification committee is not on record. Accordingly, the respondent authority is directed to produce the pen drive with respect of the statement recorded by the verification committee at the time of examination of the donor, recipient, and the guardians. Let the pen drive be produced before this court on 20th August 2026. This is the matter on 20th August for production of pen drive.
May I have a copy of it so that I can take instruction from my client also?
Which one?
That recording of the video.
That recording comes when we see to this.
My lord, I am praying one indulgence. My item was item number 13. I was engaged in court number 15 and 12 is Passover matter. That's why I cannot reach at the time because
when you will get the time you come. Yes.
My lord, it was directed to take monthly list. My lord, kindly, my lord, make it not today, tomorrow. That is Monday.
You persons knowing the morning how you are torturing this court 10:30. Then I am also torturing all of you if you are not appearing.
I will come on Monday.
Take and give. Yes. Next.
What's I am for the petitioner. Another matter relates to.
Lord, several occasions time has been taken. I will not take time. But
Yes.
Lord, what I am humbly submitting is that Lord, we are all bound by a resolution. I was the ex-secretary of the bar. Now I following the resolution. My lord, what I am just opening the case, my lord, it will not take more than 2 minutes because I am on giving a proposal subject. My lord, here the entire case is based on. My lord, just give me 1 minute. I'll explain. Freedom fighters pension. Father was an accepted, proclaimed freedom fighter. He was getting pension. Mother was also getting. Yes. Now the daughter has come up saying that I am unmarried. I'm not going to technicalities, Lordship, that I will argue. Now, Lordship, what has happened is, mother's case, the long and short of this matter is that mother has died, and after that, after a considerable delay, she has made an application and she has come before this honorable court. Even much after that, about 4 years delay, I'm not joining on issue. There, in this particular scheme, Lordship, what happens is that 6 months continuous watch is to be kept as per the scheme, whether the unmarried daughter has got married or not. So, Lordship, and all those things are very executive in nature. I'll not say something which is, my lord, and he has made a representation. It's subject to, and that is P10. My lord will kindly say.
Case 39.
Case 39. If that his allegation is that we have not considered it, though all the documents he has placed, how he has become privy to those documents, that we are asking for details from the state government, I am not joining issues there also. But Lordship, the matter can be cut short if we are directed to consider the representation. My lord will kindly see 39. Or on the contrary, if my lord wants to have a, then my lord, I will take instructions. But my lord, I assure my lord, we'll get. So my lord, one I can suggest, subject to he not joining issues, and whatever is falling from my lord will kindly take up page 39, my lord. My lord has got it. My lord, this is the representation.
22.
Now, Lordship, it was made in 2022. Once, my lord, innocuous prayer can be, lord, they will be considering it within, and then they, because, my lord, if they come up, because here, my lord, I, without instruction, I can assist my lords to this aspect or on the technical grounds, which the only weapon which is always available with the union and the state government. But I don't want to go on that aspect. I am prepared with that. But my lord, what here I am seeing, my lord, is my lord will kindly see. This lady is saying that I am entitled being a...
When mother died?
So mother died 27th
April
2020. April 2020. Thereafter, I applied 2021. Some months. Thank you.
Lordship, on 20, call of action actually arose on 27th April 2020. They applied, if I am incorrect, please tell me.
No.
The application was made by them in January 2021. And this writ petition was filed by them in November 2024. So they were sleeping over there, right?
In the meantime, their verification, I have to appear their office to.
So what do you want? Consideration of your representation, you want this court has to decide on merit. If you say decide on merit, then I will tell them to file report.
Yes.
If it comes with the affidavit, then you file the reply, then it will
They are
say.
saying that delay, no delay. In between.
Leave aside the delay and all these things. Yeah, there is no 4 option, only 2 options. Correct. 2 options. I am not having 4 options. That you will get at 9 p.m. Correct. So whether the writ petition can be disposed of by considering this representation, or you want this court has to dispose of on merit, then I will direct to file affidavit with all documents.
Dispose the consider the representation, but that representation is not.
Going into the merits of the case.
Consider the representation. But it is not elaborate. It is some they have on.
That's why I'm asking.
To make representation afresh.
No, why?
Let them file affidavit.
That's a consider.
Let them file affidavit.
No, representation consideration. It will take more time.
My lord, I said that if my lord allows me 2 minutes, will not matter maybe.
The grievance of the petitioner is that the father of the petitioner was getting Swatantrata Sainik Samman pension. After the death of the father, the mother of the petitioner was getting this. The mother of the petitioner died in the year 2020. Subsequently, the petitioner has made representation to the authority for grant of the Swatantrata Sainik Samman pension to the petitioner as the petitioner is an unmarried daughter and is not having any income. He submitted the respondent authorities have made several correspondences with the government and state government, but till date no final decision has been taken. He submitted on lastly on 11th of 7/2022, the petitioner has made a representation to the Undersecretary to the Government of India, Ministry of Home Affairs, Freedom Fighters Division, for consideration of the case of the petitioner for grant of Swatantrata Senani Samman pension, but till date the request of the petitioner has not been considered. Learned Council for the Union of India submit that if a direction is passed, the authority will consider and pass appropriate order in accordance with the law. Consider the submission made by the council for the respective parties. The writ petition is disposed of by directing the respondent number.
Respondent number.
Respondent number 2. Respondent number 2.
Or any of his.
Respondent number 2 or any of his authorized officer shall consider the representation submitted by the petitioner dated 11th of July 2022 and pass appropriate order within a period of 6 weeks from the date of this.
My lord, may record, my lord, that since we have not filed any
This court has not gone into merit of the matter. This court has disposed of the authorities are free to take decision in its own merit. And as this writ petition is disposed of at the motion stage, no affidavit is called for. The allegation made therein and deemed to have been denied. Thank you. Next. Yes, which password matter? Yes, call that 12. Who is for the other side?
But I have surprisingly, they are appearing with the address. In that address, I sent the notice. Those are coming back with the endorsement insufficient address.
District Bardhaman?
Mal.
What is the order?
Malad, kindly take up, page 47. Without considering the market value and the other parameters, the value of the land has been escalated 20 times.
So how the writ petition?
Under the Telegraph Act.
Telegraph Act?
Under the Telegraph Act.
Yes.
Initially,
who is the authorities?
The district judge passed the order.
No, the authorities, who are the authorities?
The petitioner for the DVC.
Respondents?
Respondent is the land loser. First one is the land loser. Second one is the district judge.
It cannot be. State of
Principal said a Department of Power and Non-Conventional Energy.
You are the Damodar Valley Corporation. And who is the respondent number 1?
Respondent number 1 is the land loser.
Land loser.
Well, initially, she accepted the proposal. I have annexed that. After that, she filed that, wherein she paid for 20 times escalation of the market value. That has been done without giving me notice. Your Lordship is aware of very much aware of the fact that Section 80 notice is required when an authority is party in the proceeding. That has not been done. Even then, it has the order has been passed in our absence by escalating the market value 20 times. Well, I am facing is because of the fact that one execution application has been filed.
Who?
This land loser. She is not accepting our notice in appearing before the court and pass the execution.
When is the date before the executing court?
My lord. In the mentioning slip, I have given Lord the.
Have you served? What is the report?
Lord, it was on 30th July 2026. The notice we have received. Mentioning slip, my lord, mentioning slip is on on 30th July. The last date was 30th July 26.
Sufficient address.
Well, in that address, she appeared. Kindly have a look at the execution proceeding where her address is same as written in the writ petition. But it's being coming back. The letters have been coming back with the endorsement insufficient address.
Yes. So,
my lord, I want an adjudication so that my lord, this can 20 times escalation without anything, without any report, without calling for any document, my lord.
okay, you do one thing today also the bar resolution is there might be some advocate may appear. So you is again inform the date not to send the notice on the said address.
My lord.
9 fixing, she will not come then.
But in the meantime, may I humbly request one thing, my lord? The mis-execution case, my lord, will be taken up shortly, my lord. Kindly protect me till that, my lord. Otherwise, I have to face the execution also.
File application before the court.
As well.
Kindly indicate not if the
I have
not considering then come.
I have prayed that, my lord. Kindly indicate that. My lord.
The petitioner has filed affidavit of service wherein it reveals that the notice upon the private record number 1 is written unserved with the endorsement insufficient address. Now, counsel for the petition submit that the respondent number 1 has initiated this case before the learned district judge with the same address, and now the respondent number 1 also initiated an execution proceeding under the same address, but intensely she has refused to accept the same. Full stop. In view of the above, for the interest of justice, the case is adjourned. The petitioner is directed to again inform the date of hearing to the respondent number 1 and to file a press affidavit of
1
service.
and 2, my lord. 1 and 2. 1 and 2.
1 and 2 with the respondents. And to file affidavit service, it is made clear that on the date fixed, in spite of having the knowledge of the date, if none appears on behalf of the respondents, the separate petition will be taken up for hearing in the absence of the respondents.
Will we appear before, my lord? Appear on, my lord?
Let the matter appear on 27th.
Well, in the meantime, will kindly grant me leave to pray for adjournment before the court.
Learned counsel for the petition submit that the private respondent number 1 is proceeding with the execution proceeding, the petitioner is at liberty to pray for adjournment before the
Get 27, may I pray for within the first 10 minutes, if your lordship so pleases, my lord.
Okay, then 28 within 10 minutes.
Grateful.
Next.
But I am for the petition in item number 90.
Yes. Who?
Well,
Yes.
there are two things, my lord. First, I want to indicate, my lord, I need to correct one of the party. However, he is not the proper answering necessary party. Instead of making the DM Bhagwan as a party, we have made DM Madla wrongfully as a party. Well, he is not the answering respondent. It is the necessary party is the the state transport corporation, South Bengal Transport Corporation. My lord. What has happened? My lord, kindly come to page 32 once. Where SBSTC entered into an agreement with the petitioner's concern. Page 32 is the subject matter of this agreement. In consideration of the payment to be made by the agency to SBSTC, as hereunder mentioned, the contractor hereby covenants with the employer to provide a suitable hub with enough parking space for SBSTC buses, modern refreshment and toilet facilities for passengers and various infrastructures in between Mokut and Mutipur. SH 17 of this agreement and the tender documents. Now thereafter this was constructed by us with a legitimate expectation that buses will stop, as this is also kindly come to the second part. The agency hereby covenant SBSTC in consideration of the execution of completion of the work services as per the provisions of the agreements. The first party hereby agrees to give stoppage to all the buses for a period of 30 years as mentioned in the terms and conditions of the NIT. So, Lordship, this stoppage of the buses is connected with the agreement itself. Now, 30 years was there, my lord. Thereafter, Lordship, kindly come to page 34, my lord. This was 31/12/2020. As decided and approved in its 159th meeting, the corporation board held on 21st November 2020 for providing a suitable hub with enough parking space for SBSTC buses, modern refreshment toilet, various infrastructure in between Mongolkot and Murotipur and Umarpur, Muhibul Alam Mondal and Ismatara Begum, resident of village Murotipur, Purbo Bardhaman, has been entrusted to construct. But kindly maintain the same. If any report received by the SBSTC authority that the buses are not stopping at the hubs constructed by Mohibul Alam Mondal and Ismatara Begum, they will be compensated from our corporation. I wish them success such and such. This was issued by the managing director of Godala Kiran Kumar, IS, SBSTC. Thereafter, my lord, kindly come to page 37. Now, this was issued on 7/2/2022. This is to inform you that when it is requested the corporation buses passing through that road should utilize the hub, both upward and downward journey, not to have in any other places hub on the way. So these are connected. So legitimate expectation was grown, but Lordship, what has happened? This after change of the party concerned in the state, Violet, that they have stopped this. I made a representation which is featured in page 38. It is addressed to the Managing Director of South Bengal State Transport Corporation. Violet, kindly, I have stated everything here. Violet, the relevant paragraph, Lordship, page 42, that my client has incurred substantial expenditure towards acquisition, development of the land, construction facilities, maintenance, but now the buses are not making their stoppage there. That is the problem, my lord, I am facing. So we have a legitimate expectation, my lord, from the WSSTC that they should direct the buses to make their stoppage in that.
Yes. The problem. Where is the decision taken by the authority now?
Well, a decision, there is no such decision. This is a change. They are not stopping. So we made this representation before the SBSTC.
So if they are not stopping this up, where they are stopping?
They are just bypassing it. There's some new things that may have been dropped up. So that is.
Yes. Today is the date. Huh? Counsel for the petition has argued the matter is lent. Counsel for the respondents prays for time. Let the matter appear tomorrow.
Tomorrow. Monday.
Yes.
But the affidavit of service be kept to the Monday within first 20 matters.
Within 15 matters.
Grateful.
Yes, original side.
Mr. Vegan, affidavit of service. Affidavit of service now.
কিছু নেই।
Item number 1, special fixed fee.
Lord, I appear for the writ petitioner, my lord. This is my affidavit of service.
Yes.
Lord, I have two affidavits of service. First, showing service of the writ petition, and second, my lord, we had mentioned the matter before your lordships when my lord was pleased to fix it today at 3 p.m.
Yes.
That is also notified to the respondents.
Yes.
My lord, I have handed over both the affidavit of service.
HDFC, Axis and
Reserve Bank of India is the respondent number 1.
Yes. What is the matter?
My lord, my challenge emanates from RBI Master Circular, my lord, on unauthorized transactions. My lord, the circular is essentially to safeguard and protect the rights of the customers who've been a victim of cyber fraud. Now, my lord, in this case, there were unauthorized transactions in my account on 16 December 2025, both with HDFC and Axis Bank. There was a pre-sanctioned loan which was also debited from my account. Thereafter, my lord, I immediately informed the banks that this has happened, kindly freeze my account. My lord, those documents are on record. Thereafter, my lord, I have filed a FIR also. There's a finding of the IO that there's been a cyber fraud, and they've been able to recover about 91,000 out of a total of 9,91,000. That order is also there of the learned Chief Judicial Magistrate. Thereafter, my lord, I've been writing representations first to the respondent numbers 2 and 3, and thereafter, my lord, the respondent number 1 act in terms of the circular because the liability of a customer is 0. So I'm entitled to have the unauthorized transactions reversed with a period of 10 days from me notifying the bank. Now, my lord, I have gone up to the RBI, I've gone up to the banking ombudsman. They have closed my complaint, but at the same time, they've directed the respondent number to just refund the sum of rupees 1,20,000 as compensation, and they've closed my case. Now, my lord, if that is the case, there's an admission that I'm a victim of cyber fraud and there's no negligence on my part. And thereafter, my lord, despite refunding the money, what whereas the liability is 0. Now, if your lordship will kindly take the circular ones, then I'll show your lordship the documents. You know, the circular is at page 85. If your lordship sees, the circular is on customer protection.
But even though
yes,
you file the affidavit, but as per the bar, how it can be expertise can be taken?
Well, my lord, in that case, if your lordships may kindly keep it on Monday, my lord, because I am praying for an interim relief.
Record and order. The petitioner has filed the affidavit service, but in spite of service of notice, none appears on behalf of the respondents. Due to the bar resolution, the case adjourned. Let the matter appear to Monday.
My lord, will it be your lordship's pleasure to fix it at 3 p.m. if possible?
In September.
Okay.
You
Then,
just fix it, then you come to the.
my lord, then file at the top, my lord.
Let it see what.
Very well. I'm grateful.
Next.
Your Lordship, I am appearing on behalf of the petitioner. On the last day, your Lordship had noted that if a supplementary affidavit is filed by the biological father saying that he has no objection in change of Aadhaar, then you will allow it. Your Lordship, kindly pass an order. Your Lordship may kindly pass an order allowing me to add a party in it, because since there is no order on record showing that addition of party can be done, the department is not letting me add a party.
Where is the address? What is the name? How you add?
Your Lordship can just add biological father, but it's there in the.
Where is the name and all these things?
It is there in the application, Your Lordship, in the deed of adoption on annexure 2, page 18. Also, the details of the father is there.
Yes, what was the name? Sushil Kumar?
Sushil Kumar Balodia.
Record and order. The petitioner has filed the present writ application praying for a direction upon the Unique Identification Authority of India within bracket UIDAI, Kolkata, for disposing of the representation of the petitioner dated 19 January 2026. 2026 by by correcting the name of the father.
In the name of the father.
By correcting the name of the father of the minor.
Minor, your lordship.
Of the minor. Minor in the Aadhaar number 9638-6149-4874. Full stop. This court find that the petitioner, the minor, is the adoptive daughter of the petitioner's hearing. The biological, this court find that before passing any order, an opportunity of hearing is to be given to the biological father of the minor. Accordingly, the petitioner is directed and is given liberty to add the biological father of the minor as respondent number
3.
Respondent number 3 in course of the day, and to serve notice upon the added respondent and to file the affidavit of service on the next date fixed.
Your lordship, one minor addition. Can you please direct hand addition? Hand addition.
Yes, today.
Deeply obliged, your lordship.
List the matter. How soon you will serve the copy?
Yes, your lordship.
List the matter on 27 August.
Obliged, your lordship.
But this is the matter, my lord, where the jurisdiction issue was being argued as a maintainability. That is the problem.
Where are they? Where are the
response?
Nobody is here. That resolution. Not today.
You're appearing on behalf of SEBI, your lordship.
Yes.
3 and 4.
Yes.
Now, I had invited your lordship, Milord. This is that matter where SEBI, the final order of SEBI is of 2020. Now, Milord, my learned friend is correct that an appeal was carried to the Securities Appellate Tribunal, Milord. That is from an interim order. And in 2018, the appeals carried by me were not entertained and were dismissed. Admittedly. Now, Milord, the interim order ultimately merged with the final order. The final order, Milord, at various pages, Milord, obliges me and binds me with certain obligations, which inter alia includes 4 years debarment from markets. Nothing else. Now, Milord, insofar as fastening of financial liability is concerned, that liability is exclusive to the notice number 1. Now, Milord, if their case is that the SAT order is standing in my way, Milord, I respectfully say that I have not carried any proceeding beyond the 2020 final order. I have accepted the 2020 final order. My case all throughout has been I am not the director. On an elaborate examination of all the materials on record, the SEBI comes to a conclusion that yes, notice number 2, he would be bound by these liabilities. Notice number 1, these liabilities. So therefore, Milord, thereafter, recovery proceedings having been initiated, Milord, there are 2 things. The 2024 order, which is the impugned order in the proceedings, which, Milord, freezes my bank account. Milord, it is in the nature of a 28A direction. Section 28, capital A direction. Whereas, Milord, the final order is in the nature of 11B. Now, 11B I have not violated. In the absence of any such collateral finding, Milord, fastening me with a financial liability does not and not cannot arise. Now, Milord, just to sum up, Milord, my arguments, I don't have anything beyond this. Milord, please see the impugned order. The impugned order is at page 125, 124.
Yes.
It fastens me with, Milord, a combined liability of 9 crores and odd, page 124. And my lord, the final order begins at page 68, before the Security and Exchange Board at page 68. My lord, the relevant portions I invited my lord's kind attention to. Paragraph 29. At page 64.
Not liable to making any refund of the fund.
Page 64 is my only, my lord, punishment if at all. Paragraph 29. So, but this being the factual backdrop, my lord, this page 124, fastening me with a financial liability and freezing my bank accounts, my lord, cannot stand. Because, my lord, the 2018 SAT order is against an interim order, not the final order.
Yes.
Now, my lord, just to assist your lordship a little further, my lord, please take the trouble to kindly come to 27. My lord, 27 is an interim order come show cause notice. My lord, very kindly seen it, my lord. And my name figures at serial number 3.
Yes.
My lord, my submissions have been recorded in page 28. Shri Kali Kishore Bakshi, somewhere in the middle, paragraph 22.3, somewhere in the middle.
Yes.
Shri Kali Kishore Bakshi replied that he had resigned from the said company in April 13. It was also submitted that Mr. Dujari of the company had misused his name and hence he resigned from the company as a non-executive director. It was also submitted that he was in no way involved with the company and he had no control to supply documents sought by SEBI as the same are in control of CMD, etc. Thereafter, straightway, the issues for determination is at page 30, 3.3.
Yes. Yes.
Then the directions at page 35.
The interim direction.
Yes, shall not access the securities market, buy, sell, etc. That is at page 36. 36.
4.3.1.
Yes. Yes.
Calcutta
Yes.
to jointly and severally refund the collected amount. The company 15% per annum. What was the amount?
That is not reflected. That is not reflected. Subject to correction by my learned friend, not reflected. Now, this order, the interim order, was carried in appeal. There were 4 different directions, true, and all those were carried in appeal. The appeal stood dismissed, not entertained in 2018. Now, ultimately, this interim order from final,
124.
It went up, the final order was passed. The final order begins from page 41, and the directions I invited your lordship, page 64.
Yes.
So, this being the position, the question of any recovery from my end, and fastening me the financial liability to the extent indicated, and that to unquantified liability. No quantification has been made, subject to correction. I may be incorrect. My learned friend will correct me. 124 is the impugned order. I am seeking your lordship's immediate protection, to the extent of defreezing the accounts.
Yes.
Your lordship, what my learned friend has done over here, he has adjoined 3 different proceedings to 1 writ petition. All the annexures which has been shown by my learned friend are of completely different things.
Lordship's uprising, I have prepared this list of dates. So, Your Lordship, there are total 3 proceedings which has been initiated against the writ petition. Yes, yes. Just a minute, I'll show you.
এয়ারড্রপ করে দাও
I will airdrop it.
এয়ারড্রপ করে দাও আচ্ছা
So, Your Lordship, there are 3 different proceedings which has been initiated against this company. Your Lordship, the first proceeding was in February 2016. The second was on 26th February 2016. And the third was on 24th November 2020. Now, before I get on to the writ petition, I just want to give the brief background of this entire case, that what is happening here. Now, Your Lordship, I have given what SAT order to Your Lordship, which is very important and which plays a very crucial role in this entire writ petition. If Your Lordship has that SAT order, I will just hand over.
Yes.
Yes, it is of 10th January 2018. Your Lordship, I will just...
Which chart? This one?
Yes, 10th January 2018, Your Lordship.
This one.
It's a SAT order. I'll hand over.
Achha, this is. Yes.
So, Your Lordship, out of 3 proceedings, 2 proceedings...
This is appellate type.
Yes. So, out of 3 proceedings, 2 proceedings has been challenged by the writ petitioner before the SAT authority, which is of 23rd February 2016 and 26th February 2016. Before I got into the third proceeding, I will just read out the relevant portion for Your Lordship.
SAT order?
Yes, SAT order. Now, Your Lordship, if Your Lordship come to page 3, and Your Lordship come to page 2, I will read para 3 onwards. So, para 3 reads, by order dated 26 February 2016, which is impugned in appeal number 142 of 2016, the whole-time member of SEBI has directed Amrit Project Limited Company and its directors, including the appellant, which is the writ petitioner herein, to jointly and severally refund the money collected by the company through issuance of redeemable preference shares to the investor with interest at the rate of 15% per annum. Counsel for the appellant submitted that the impugned order is unsustainable because firstly, the appellant was not a director of Amrit Project Limited, which is the same stand taken in this writ petition as well, and was appointed as a director of Amrit Bioenergy and Industries Limited for development and building up a green power project in West Bengal and Assam. Since the appellant was not a director of Amrit Project Limited, the WTM of SEBI is not justifying in treating the appellant as a director of Amrit Project Limited and accordingly issued direction against the appellant. Secondly, it is submitted that as per the order dated 13th July 2016, passed by Calcutta High Court, in company petition number so-and-so, Mr. Kailash Chand Dujari, Chairman and Managing Director of the company, has taken the entire responsibility on behalf of Amrit Project Limited, Amrit Group of Companies, to make disbursement of the payment to the investor, and therefore the directions issued against the appellant cannot be sustained. We see no merit in above contention. First contention of the appellant that he was not a director in Amrit Project Limited is falsified by the written complaint filed by the appellant on 6th June 2017. The officer in charge, Beniapukur Police Station, copy which is annexed by the appellant itself to the memo of appeal at page 105. In the said letter, the appellant has categorically stated that he had joined Amrit Project as an employee in the year 2004, and later on the appellant became one of the directors of the company. Does the very same document relied upon by the appellant falsify the case of the appellant that he was not a director of Amrit Project Limited? Accordingly, the first contention is without any merit. Second contention raised on behalf of the appellant is that as per the order passed by the Calcutta High Court in company petition so-and-so, the chairman and managing director of the company has agreed to take entire responsibility to disburse the amount due to the investor, and therefore the liability fastened on the appellant does not survive. There is no merit in the contention because Calcutta High Court in the aforesaid company petition has neither considered nor modified the impugned order passed by the WTM of SEBI. Since the direction given in the impugned order to refund the amount is joint and several, if the chairman and the managing director of the company discharges the entire liability then obviously the appellant cannot be called upon to discharge the liability. However, fact that managing director has agreed to discharge the liability cannot be ground to exonerate the appellant, who, in spite of being a director of the company, has been falsely claiming that he was not the director. In the circumstances, both appeals are dismissed with cost quantified to 25,000 to be paid by the appellant to SEBI within so and so days. Both the appeals are accordingly. So, Your Lordship, the fact that he was not a director, it is very well clarified in this order. Now, Your Lordship, if Your Lordship come to the writ petition, before Your Lordship comes to the writ petition, the compilation which I've handed over. Yes. Just the compilation which we have handed over shows the 3 different recovery proceedings. Now, I will just rely on the writ petition before I get on to the compilation, Your Lordship. If Your Lordship comes to the prayer portion once. Page 21, Your Lordship.
Yes.
So if Your Lordship sees the prayer, before we get into any merits or whether this writ petition is even maintainable over here, is writ, Your Lordship, if Your Lordship sees the prayer portion B, a writ in the nature of mandamus directing the respondents to remove the debit-free status of your petitioner's saving account being account number so-and-so with Punjab National Bank. Now, Your Lordship, the second prayer, which is prayer number C, a writ or in the nature of certiorari do issue quashing any orders or directions issued by the respondent for freezing the personal bank account. Now, D, a writ in the nature of certiorari calling upon the respondent to transmit all reports of the case before the court. Now, Your Lordship, the writ petitioner over here has not clarified that against which order of the SEBI is he aggrieved of. He has nowhere clarified. What he is doing, Your Lordship, is he's showing one order of one proceeding, one WTM of order of the another proceeding. So, Your Lordship, what the proceedings are? Whole time member passes the orders, recovery proceedings take place, and then the remittance order is passed. Now, Your Lordship, you cannot show of one whole time member order and one order of the remittance. They are completely 3 different proceedings which have taken place. Now, the first proceedings has been challenged before the SAT. Now, the third proceeding, the statutory appeal lies over there. He can very well go to the SAT, whatever his grievance is, whether it is barred by limitation, not barred by the limitation, that will not give him the right to invoke the inherent jurisdiction or the writ jurisdiction and come to this court and ask that let my account be defreezed. And the 2 freezing orders which he has challenged before the SAT has reached to an adjudication. After that, you have to go to Supreme Court. So he's not even saying that he's challenging the SAT order. He's not clarifying over here.
No, he's challenging the 124.
124, Your Lordship. Now, Your Lordship sees the 124 order, which is at page number 41. Yes. Page number 41 is the order which he's talking about. So, Your Lordship, for that, he cannot come to this court. This is a statute. The statute is very clear that if you are aggrieved by whole-time member order, and he's very well aware of that proceeding, then he has to go to SAT. He cannot come and invoke the writ jurisdiction on any basis.
Who has passed this order?
Your Lordship, writ.
No, who has passed this order?
WTM, Your Lordship.
Huh?
Whole-time member, Your Lordship. WTM, SEBI has passed this. Page 41, Your Lordship, which he is challenging.
41 of your.
A writ petition. No, Your Lordship, the writ petition.
I'm not challenging 41. I'm not
41. That's why 124. Only 124.
So that is at page
124. Page 124.
So that is a remittance order which has come after the whole-time member. So, Your Lordship, the proceeding is that.
So that's why I asked the question.
Yes,
here, the recovery officer passed this order for recovery of this amount. Correct.
Correct. Your Lordship.
Where from this amount has come? Where is this total amount has come? By which order?
Your Lordship, this amount is coming from WTM's order, Your Lordship.
So 9 crore 93 lakh 29,277.
Yes, Your Lordship.
Correct. And there are how many persons are there?
Your Lordship, there are total
10
yes,
persons.
yes, Your Lordship.
10 persons.
Your Lordship,
Correct.
actually there are
So what is the amount?
14 people are there, Your Lordship.
No, yeah, this 124 showing only 10.
Yes, Your Lordship, because I'll tell you, because one is Amrit Project, the company, so that is why they're not counting it. So there are 12 people. Yes,
Okay.
Your Lordship.
No, Amrit project is there. Amrit project is also there.
No,
That's
if you Lordship,
1 to 124. Amrit project is one for number 1. Correct.
Number 2 is
And-
Kailash Chand.
And and number 6 is the Kali Kishore Bakshi.
Correct.
Correct. So now the total is a 10 here.
Correct.
Total is a 10. And now whereas the current liability, not third paragraph, whereas the current liability dues from the defaulter as on 9 crore 93 lakh 29.
Yes, Your
So
Lordship.
how this amount has come to the
Now,
company?
Your Lordship, I'll show Your Lordship once page 41, Your Lordship.
One thing first, page
Page 41, Your Lordship, which is the order of the WTM.
41.
Yes, Your Lordship.
Yes.
Now, Your Lordship, please the page 41. This is the whole time member order.
Yes.
These are the notices, Your Lordship. Now, Your Lordship comes to page 42. I'll read it from paragraph 1 itself, which is 41. SEBI has passed an ex parte interim order on 4th June 2018 against the company Amrit Project Limited and its director and promoters. Norms by the company in issuing two types of deep discount bonds, that is power bond and infra bond. Power bonds were found to have been issued to at least 830 investors in the financial year so and so, illegally raising a sum of 98,78,000, Your Lordship. It's yes, Your Lordship, it's 98 lakh. So this is showing, and then Your Lordship. What I can understand, Your Lordship, is that there are 3 recovery proceedings and the amounts, what I can understand, has been attached together. Your Lordship.
Correct. So, and there are 10 persons.
Correct, Your Lordship.
So 9 crores. What amount is to be attached? Which amount is to be attached? What is the quantum of the amount of the each and every or the total? Because all are not
They are
connected.
joint and severally liable, Your Lordship. If the amount is
All are jointly and severally.
yes, Your Lordship.
So whatever the amount, it will be taken.
Your Lordship, if there are X amount
Hmm.
which is due and payable by the company
Hmm.
and its directors and promoters, so if X minus 1 is recoverable from one person's amount, then the rest of the amount will be recovered from the other 14 or 12 people from their account.
Correct.
This is the recovery proceeding says so, Your Lordship.
Correct.
But Your Lordship, before we get on to that, even how much amount is due and payable by the writ petitioner or by the other promoters, the question lies over here is that why is that order being challenged in this court? This is the main question, Your Lordship, whether this writ petition is even maintainable.
Why?
Whether High Court can look into it or whether
Why?
Your Lordship, the writ jurisdiction cannot be in.
Why? That's correct. Why it is not maintainable? Tell me.
Your Lordship, because there is a statute. SEBI, the
Show.
Yes, Your Lordship, I'll show the relevant act.
So the statute, the recovery officer notice is available.
15T, Your Lordship, of the SEBI Act once.
Section
15T, Your Lordship.
recovery officer's notice is applicable. Recovery of officer
15T,
notice.
if I may read it, Your Lordship.
Yes.
Appeal to the SAT. Save as provided in subsection 2. Any person aggrieved by an order of the board made on and after the commencement of the securities law under the act or the rules or regulations made thereunder by an order made by an adjudicating authority under this act may prefer.
Which section?
15T, Your Lordship.
15E.
T.
Yes. Save as provided by an order of the board on after commencement, an order made by the adjudicating officer on order of the Insurance Regulatory Development Authority or the provinces may prefer an appeal. Yes.
By an order made by adjudicating officer under this act,
Hmm.
may prefer an appeal to this act, having jurisdiction in the matter.
Where it's set? Prefer an appeal, every appeal.
Under subsection 1 shall be filed within a period of 45 days from the date.
Where is the by an order made by the adjudicating authority?
Yes, Your Lordship.
Yes. Yes.
The statute is very clear on that, Your Lordship. And Your Lordship, what I can understand from this writ petition was the first two recovery proceedings were challenged. He did not get a favorable order. So in the third order, he does not even want to get onto the SAT authority, and he's over here.
Okay.
Which is very clear, Your Lordship.
That's all.
Your Lordship, I can bring some judgments on that, Your Lordship, if Your Lordship allows. However, this is my very limited submission on the
If you submit, then I will conclude this. If you say that you will want to submit further, then I have to grant time.
Your Lordship, before I get onto the merits, I'm on the maintainability of this writ petition.
Okay. That's all.
Yes, Your Lordship, only onto the maintainability.
Yes, Mr.
My preliminary submission, if it's an action without jurisdiction, if it is an action without jurisdiction.
Why without jurisdiction?
Because, the final order of the whole time director does not bind me with anything, apart from directions. There is no, please, my honest friend has perhaps not shown Your Lordship section 28A. 28A is the order, the basis of page 124.
So you prepared an appeal.
I cannot.
Why?
Because 15T does not say of 28A. It's not from 15T is not from a recovery officer's order.
Yes.
15T, subject to correction, is from the SEBI's order.
No.
I am not aggrieved by the SEBI's order. The whole time director's order.
By an order made by the adjudicating officer under this act.
The recovery officer is not an adjudicating officer. He is an officer specially constituted under 28A. 28A, provided there is a violation of 11B direction.
Yes.
Please see section 3. Establishment and incorporation of the board. Management of the board. Chairman, 2 members, 1 member from Reserve Bank, 5 members of at least 3 of whom full-time directors to be appointed by the central government. Section 4(1), not A, B, C, D.
Yes,
This is the board.
just madam, come to the 28A.
Yes, Your Lordship.
Correct. Come to the 28A.
No.
Shall proceed to recover from the person the amount specified in the certificate by one or more of the following modes. Where is the so that's why I'm again and again asking where is that certificate from whom the recovery officer is demanding that amount.
Your Lordship, let me show you the recovery certificate, which is not annexed over here. And it is not even there in my compilation.
Correct. Because here says the shall proceed to recover from the person the amount is specified in the certificate by one or more of the following names. So attachment, whatever it is. So it is a recovery under 28A. Correct.
Yes, Your Lordship.
Under 28A. And the recovery, the total amount you are asking for the 29 and 9 crore something. 9 crore 93.
Correct.
So where is the recovery certificate on that's why you again asking how this figure has come.
Your Lordship, he has not annexed it. It is not even there in my compilation. Let me bring the certificate.
and the order recovery amounts of the recovery officer issuing the notice is an appealable order.
Yes, Your Lordship. It is
Why?
appealable.
Kindly come to 15T again.
Yes, Your Lordship. If we see 15T,
15T is not an order, it is only recovery on the certificate.
Your Lordship, it says by an order made. First, it says by an order made by an order of the board made on and after the commencement of the SEBI under this act.
Correct. This is not the board. This is not the board order.
But Your Lordship, what I'm saying is that what he is doing is coming from WTM's order.
May be coming from now come to the if the 15T provides either the board or the adjudicating officer or an order of insurance regulatory development. That is not there.
Recovery officer, if we see the definition of recovery officer once, it's not.
Read.
It's not mentioned. It is not mentioned.
Because it can't be because recovery.
But Your Lordship, without interrupting my learned, I'm telling Your Lordship, this recovery proceeding is apropos a direction made under 11B which has been violated.
Correct.
Then only a question of recovery comes and a certificate comes.
That's why 11B 28 provides the recovery.
Whole-time director's order, whole-time member's order, she is correct. That order, is on the basis of 11B direction.
Correct.
I am giving 11B directions. One of the directions is page 64.
Yes.
So, and fastening me with a liability which I don't have, that by itself makes it an action without jurisdiction.
Your Lordship, let me come back onto that, Your Lordship. Give me a short date.
So you're telling the three orders.
I understand.
Correct.
Your Lordship, what
If
Your
the three orders, now he has disclosed the two orders.
Correct.
The two orders does not reflect with regard to the amount, only liability source. Only liability source being a director. Correct. So now the recovery officer has come to the conclusion of attachment of the property with regard to the 9 crore.
Correct.
If the 9 crore, then how the 11B order has come?
I get what Your Lordship is saying. I will convince Your Lordship on that issue. It's
So
a
that
very
is-
small issue. Before we get on to anything, any merits also. So let me get on to that. Your Lordship, my friend is also present. Both are comfortable and mutually agree on if Your Lordship can post the matter on
I
Wednesday.
need it to the court any day convenient to the
Your Lordship, just
Your Lordship, Monday,
just, Your Lordship.
if the matter is posted, I'll be virtual.
Monday, no, Monday.
No, Monday, Tuesday, Your Lordship, there's a personal difficulty from my side. But when any day as per
Let the counsel for the respective parties have argued the matter at least fully. Counsel for the respondents pressed for time to take instruction. According case is adjourned, let the matter appear on 20.
very well.
Thursday.
Very well. Obliged.
Within the same group, same heading.
Lordship, may I seek your indulgence, Lordship. Yesterday I have mentioned one SIR matter. The verification has been stopped, Lordship, due to my name has been adjudication, not deleted, nothing, Lordship.
So what has happened?
The other petition have given appointment, only my appointment has been stopped, Lordship.
So what has happened?
Nothing, Lordship. Due to my
Yesterday mentioned it was not come.
yesterday I have mentioned one leave and one mentioned leave, but matter is not being leave matter has been appearing, but my matter is not being appeared.
Appeal said nahi.
Grateful.